Good morning. Today is Wednesday, February 1st, and we are convening the public hearing. It's 11:03 a.m. for the Planning and Development Committee. Any remarks by my co-chair?
Thank you, Madam Chair. Good morning, everyone. Thank you for being here. Happy to have you all. We look forward to listen to you and have the prospective meeting today and hearing. Thank you.
I'm not seeing Senator Fazio, so Representative Zullo.
Thank you. Good morning, Madam Chair. Echo the comments of the good senator. Looking forward to hearing the diversity of viewpoints on all of the items on the agenda, and eager to get started. Thank you very much.
Thank you. First up today, we have Peter Myers from CBIA.
Good morning, everyone. I'm excited to be batting lead off today. I never got to do that before. So good morning to the chairs, ranking members, and members of the Planning and Development Committee. I am Pete Myers. I'm a public policy associate at the Connecticut Business and Industry Association. Thank you for the opportunity to provide testimony in support of two bills today, starting with House Bill 6558, an act concerning property tax abatement for certain first-time home buyers. 6558 would provide municipalities with the ability to provide a property tax abatement of up to $500 per year to first-time home buyers who purchase the property using funds provided by the Connecticut Financing Authority. CBA supports this bill because it is a creative solution that would help to create more affordable housing options for workers in Connecticut. One of the major issues impeding the growth of Connecticut businesses is the lack of affordable housing options in Connecticut. Currently, our state has 102,000 jobs open. To fill those jobs, we need to keep our workforce in state, and we need to attract out-of-state workers. To do that, we must have an affordable housing options for our workforce. We are pleased to support this bill, which would help to move the needle on establishing more affordable housing options for Connecticut workers. Additionally, CBA would also like to voice our support for House Bill 6557, an act increasing the amount of tangible personal property owned by a business organization that is exempt from the property tax. We believe this bill would have a positive impact on the business community and ask the committee to support this bill as well. Thank you for your time, and I'll take any questions.
Just giving everybody a minute to see if we have any. Representative Zawistowski. I'm going to get it.
Thank you, Madam Chair. That's fine. I've had it mangled so badly. I certainly don't take it personally, and it's not that hard. But anyway, I'd like to thank you for being here today and supporting these two very good bills. I know that I believe you're the only person who's going to be in here testifying on. Hold on here on 6557. Relatively new glasses. I'm trying to deal with it. Anyway, I know CBA as a business organization would be generally in favor of it, but in your opinion, would you more favorably impact larger businesses or smaller businesses?
Sure. Thank you so much for the question. We believe it would affect both large and small businesses, but particularly it would impact and benefit small businesses.
Yeah, I think small businesses would tend to hang on to things a little bit longer as well. This proposal would phase out assessments for people who don't have the information in front of them, phase out assessments on personal business property after 10 years. I think a lot of people don't realize that. And just with a limit of an original $1,000 purchase price, I think a lot of people don't realize that if a business purchases some type of fixture of equipment, they're on the hook forever on paying taxes. One of the examples that I have that I put together is if you have somebody buying something as simple as a filing cabinet for about $850 this year, they're paying for 10 years on that a total of $155.59. And that's assuming the average mill rate in the state of Connecticut is 31.5 and assumes no tax increases over that period of time, no increases of mill rate. Beyond that 10 years, they're still paying. you're paying in perpetuity on anything that you're trying to keep in service. So I think CBI appreciates and understands what this actually does to businesses. And there's a minimal impact on municipalities as well. But I do appreciate CBIA testifying in favor of both of these bills. The CHFA bill is very interesting as well. And I think we may have other members that may be interested in speaking on that. So thank you, Madam Chair. Thank you for coming in today.
Absolutely. Thank you for your question.
Thank you. Representative Zullo.
Thank you, Madam Chair, and Rep. Zawistowski certainly asked my questions on 6557, so I appreciate that. And just very quickly, I wanted to make sure I understood, and I appreciate your testimony on 6558. So you see 6558 as a potential economic driver then?
Yes, thank you for the question. Absolutely. At a time where one of the biggest issues we hear from businesses in Connecticut is to bring workers to Connecticut and to keep our workforce here, we need an affordable housing option to do that. And I believe this would help to create an affordable housing option, especially for first-time home buyers who want to purchase a home.
Perfect. I appreciate it. Thank you very much for the testimony today.
Thank you for your question.
And thank you, Madam Chair.
Thank you. Representative Baumgartner.
Yes, thank you for taking the time to testify. Just one question. Would it make sense to include other type of loans in the legislation?
Other types of home, meaning those that are not under a Connecticut Housing and Financing Authority?
That's correct.
I believe, and yes, that would make sense. I believe the point of the Connecticut Housing Financing Authority is it counts as a low income, counts as the town's low income affordability goals. So that was our intention of supporting that there, but we'd be open to discussing that further. Absolutely.
All right, thank you.
Thank you. Seeing no other questions at this time, thank you so much for your testimony.
Thank you so much.
Up next, we have Gary Getz to be followed by Marjorie Shansky. Mr. Getz, are you with us? Okay, I think we don't have Mr. Getz quite yet, so we'll move on to Marjorie Shansky and then Kathy Flaherty.
Good morning. Representative Kavros DeGraw, Senator Rahman, Representative Chafee, Senator Needleman, Representative Zullo, and Senator Fazio. My name is Marjorie Shansky. I am a land use and zoning lawyer in private practice based in New Haven, but practicing up and down the shoreline and the interior for over 37 years. I'm a member of the Planning and Zoning section of the Bar Association and associate myself with the section's letter of support, which is in the record. I am speaking in favor of Raised Bill 915 relating to the granting of variances by zoning boards of appeals. This amendment codifies widespread practice, demystifies the variance process, and introduces equity and defensibility into the administration and judicial review of variances that may be appealed. Because I am speaking early to this hearing, I hope to explain why the amendment to 8-6 of the statutes is important and long overdue, and I hope you will ask me questions if the goal of this amendment seems abstract to you. Regulation of land use by the government, by local government enabled through state law, that is zoning, has been in use in Connecticut for about 100 years. The local zoning authority, the zoning commission or the planning and zoning commission in your town, adopts zoning regulations and reviews and approves or denies applications under those regulations. The variance, the subject of the legislation, is the escape valve that was made part of the zoning regulatory scheme to provide flexibility where circumstances on the ground warrant and to avoid a taking by overregulation. The variance is permission to deviate from the zoning regulations. Evaluating variance requests is the domain of the Zoning Board of Appeals, and the longstanding statutory standard to qualify for a variance is demonstration of, quote, exceptional difficulty or unusual hardship, end quote. The legal hardship must come from the application of the regulations to a specific piece of property, and it must be unique. This is an extremely difficult standard to meet. Now imagine that a neighbor wants to add a dormer to their home to convert an attic to a bedroom, but the proposed dormer extends into the required zoning setback. A variance is required. Legal hardship? Nowhere in sight. Yet on most nights in Connecticut, a ZBA will grant that request because it is both reasonable and not disruptive to the general plan of the town. If the decision is appealed to court, however, it is more likely than not that the variance will be reversed because there was no legal hardship. The amendment for area
Your
variances.
3 minutes is up. Please summarize.
The variance legislation replaces the hardship standard with a rational balancing test and offers defensibility of decisions that is currently missing. It will not make obtaining variances easier. It will make them defensible, and I urge its adoption, and thank you for the opportunity to contribute.
I think that's one of the best summaries I've ever seen. So thank you for that.
Thank you.
Do we have any, I see Representative Dubitsky has a question.
Thank you, Madam Chair. And thank you for coming in, Ms. Shansky. It seems to me from your testimony, and correct me if I'm interpreting this incorrectly, that your position is that this is being done anyway, and it's being done because it's reasonable, and the only time that it gets to be unreasonable is when it gets to court. Does that sound sort of like what you're saying?
I would say, except for the unreasonable, it doesn't become unreasonable when it gets to court. It becomes indefensible because it lacked the demonstration of hardship, which is a very high threshold to cross. So yes, 80 to 90% of variances being granted are illegal insofar as they don't have a hardship underpinning, but they are not necessarily destructive to the town because they are reasonable. They may be good planning, they simply may be an accommodation. And so from an intellectual dishonesty perspective, and because from an equitable perspective, to be exposed to being overturned in court because of this artificial legal standard can be cured through this legislation.
Now, is it your belief that this should apply both to commercial construction and residential?
Yes, because there still needs to be discernment and judgment applied by the zoning board when they're reviewing a request, but it can apply over the landscape indeed.
Okay, because the example you gave with regard to adding to a dormer, that certainly sounds like a normal bread and butter request for a variance. But when I guess when you're talking about whether a Walmart should come in or not, and they need a variance, then it becomes a whole different calculation as to what standard to use and why the regulations are the way they are. But I will certainly you have written testimony as well, don't you?
Unfortunately, I do not.
No? Okay. Well, I thank you very much for coming in, and I will certainly listen to any other testimony that comes up on this issue. Thank you very much.
Even
Thank you,
though
Madam Chair.
Ms. Shansky, it's not too late to submit testimony if you'd like to do so.
Oh, very
what you shared
well.
Today, so you can go ahead and send that in.
Thank you, I will.
Representative Zullo.
Thank you, Madam Chair. And thank you, Attorney Shansky, for your wonderful testimony and for being there today, or being here today. So the example you gave was more about a setback, and I recognize that I was looking at the legislative proposal that area variance deals, it also addresses setback, things like that. I'm less concerned with a setback issue. If you want to build a porch and you're going to encroach 6 to 12 inches into the setback, I can see some of the utility of this legislation, this proposal in that regard. My concern is specifically with respect to area. So for example, you have a sliver parcel or a very small parcel, and there's a proposal to build on it, or maybe, in that regard, do you see a potential for overdevelopment or abuse in that regard with this kind of a proposal, or no?
I don't, thank you for the question. I don't see the shift from a hardship standard for an area variance to a rational balancing test as creating that opportunity, which, by the way, is being exercised here in New Haven, all over the place, unfortunately. I think actually the balancing test may be more granular in eliciting the kind of concerns that prohibit that or discourage that from occurring. So I don't think there's anything in the legislation that is going to change that calculation. I think it's simply going to apply defensibility and perhaps a more thoughtful approach and put a connection between a request and a decision.
I appreciate that. So recognizing the arbitrary and capricious standard, right, of review from ZBA, it's the Superior Court, then I'm almost thinking that this is going to be the reverse. While the majority of appeals would usually be decided in favor of the person, well, I guess in favor of the board, because I mean, arbitrary and capricious is a pretty high standard. Do you see this reinforcing that? I mean, essentially, you're going to have a whole new set of factors that a board's going to be able to rely on in justifying their opinion rather than just unusual hardship. So do you actually see those decisions being upheld more or less? I'm trying to gauge what effect this is going to have on the courts and the, you know, case log.
My study of decisions in New York that subscribes to a balancing test for area variances shows that not every variance gets granted. There's still that judgment that gets to be applied by the board. So for me, the important connection and the connection that has to do with equity and access to justice really is that you base a variance request on a set of circumstances, the board then evaluates exactly that, and the court then reviews the record based on that, and not by just applying this hardship standard on top of it that has probably been ignored all along the way, or certainly not met. So I see this as being a vast improvement.
And then the last question I had, and this is something that somebody mentioned to me in passing, would you see any utility if this were to move forward to include the ability to utilize both or either or the unusual hardship or this set of standards? Because it may be very easy. There may be an unusual hardship unique to the land that easily justifies a variance. Or if it doesn't, then, you know, you could utilize these factors. Do you have any thoughts on that?
Thank you. I don't think that the legislation supplants the ability to include within the factor that there is actually some demonstrable hardship.
Okay.
So it's sort of embedded in it. I wouldn't necessarily endorse making it a choice or having two standards to choose from. I'm so delighted that we have now Commissioner Education in the toolbox legislatively for the commissions all over the state, but I think it would be burdensome to try to add that complexity to the process.
Well, I appreciate you lending your expertise to the discussion today. I do have some concerns, but I appreciate that, you know, you coming because it certainly helps shed some light on this. So thank you. And thank you again, Madam Chair.
Thank you. Thank you so much for your testimony.
Thank you.
Moving on to our next person, we have Kathy Flaherty and then Catherine Knight. Good morning, Kathy.
Good morning, Madam Chair and members of the Planning and Development Committee. It's very exciting to be back in the building with you again this session. My name is Kathy Flaherty. I'm the Executive Director of Connecticut Legal Rights Project, and I'm here to testify in support of Raised Bill 6559, an act concerning zoning regulations and community residents with suggested language changes. I submitted written testimony, but what I want to do is read you the 21st article of the state constitution, which amended the Fifth Amendment to say, no person shall be denied the equal protection of the law, nor be subjected to segregation or discrimination in the exercises of enjoyment of his or her civil or political rights because of religion, race, color, ancestry, national origin, sex, or physical or mental disability. That was adopted by this state November 28th, 1984. The statutes you propose to repeal in this bill were implemented in February of 1984. And despite the fact that they were amended in 1985, 1990, 1993, 1995, and 1997, nobody thought to compare them to the state constitution, which makes the existing statutes illegal. It is far past time that this language be raised. And the suggested language change that I would urge is that instead of importing the language from the current section 19A 507A, where you define mentally ill adult, which is something that should never be defined in our statutes anyway, I would suggest that the committee raise substitute language and just use the definition that's in the current statute 8-3E. Persons receiving mental health or addiction services and necessary staff persons paid for or provided by the Department of Mental Health and Addiction Services. Thank you, and I'm happy to answer any questions.
Thank you so much for your testimony. So if I'm hearing you correctly, by passing this bill, we would basically be finally making what I would consider to be an ADA fix, because 3 of the years that you listed were actually after the adoption of the Americans with Disabilities Act. So it stands to reason that the law has been basically going around the ADA for 30 some years.
And the Federal Fair Housing Act too, which was where the amendments regarding disability were added in 1988. And then you had the ADA in 1990. And, you know, literally, you really wouldn't do this about any other protected class that I listed out. And to think that we actually have statutes that say, oh, if a municipality wants to have multiple community residences, we need to make sure they don't exceed a certain percentage of the people in the town. That's absolutely horrifying that this is actually still in our state law. So it would be an embarrassment for this legislature not to pass this bill.
And because of your background with disability rights, you mentioned the percentage that is in existing law, but also the 1,000 feet. How do you see that as a barrier to people with disabilities?
The reality is what you're doing is you're putting challenges that shouldn't exist in people being able to live in the community. I also would say the reason you really need to change the language for how you define what a mentally ill adult is. Again, I can't even imagine that I'm wrapping my head around the concept that we put that in the law anyway. But the way the current definition says is that if a person becomes committable, basically for either mental health or addiction services, all of a sudden they're not mentally ill anymore, which makes no logical sense anyway. But then you're basically saying, well, you can't live in the community because at some point you might relapse, and everybody who's part of the recovery community knows that relapse is part of people's recovery journey. So I don't know who wrote the law, and it was written back in the 80s. I was in high school and college in the 80s, but somebody at some point in the intervening years really should have taken a hard look at this and made it better.
And to that point, I think that, you know, our definitions of mental illness have changed over time, and to be more inclusive of many different kinds of disorders. And so I think it's important that, you know, we change as medicine changes, and as care changes. So thank you very much for that.
And I think just the last thing I would want to point out is there is a point where it would exclude people who are in the forensic mental health system. And I just think people ought to know that there currently is a lawsuit pending in federal court about the way our forensic mental health system works. And part of that is that by not providing adequate opportunities for people to continue their recovery in the community, people are segregated and discriminated on the basis of their disability. So it's just something to think about.
Thank you. Seeing no other questions. Thank you so much for your testimony today.
Thank you.
Catherine Knight, please.
Hi, thank you very much to the Planning and Development Committee for opening up and allowing me to testify. I am testifying in support of SB 917, the Title IX Working Group bill or act. I am a rep coming to the committee as a private citizen, a resident of Norwalk, Connecticut, and I'm in support of this bill. And just wanted to provide two aspects to the committee to consider. One was just the context of how this came up. And I started with a letter that I wrote to our Senator Bob Duff, about an issue that came up in Norwalk regarding Title IX and the turfing of the Brian McMahon softball field. The second part is just in terms of the composition of the working committee, to provide maybe a little bit of broadening of scope, because Title IX, according to a June 22nd memorandum 2021, Office of the Civil Rights of the U.S. Department of Education, also opens up that the enforcement is for all genders. And so to the extent, and I appreciate that it is focused on the male-female split, I think there needs to be scope to incorporate all genders, and how Connecticut plans on recommendations for being inclusive, to the extent that the athletic curriculum is based off of split up by predominantly by gender. There's very few all gender opportunities. Just in terms of the context of how it came up, is that there was a hearing, public hearing about turfing of the softball field for Brian McMahon, and Title IX. I raised up Title IX because it has been a federal law for 50 years now, and it still hasn't necessarily been codified. There's 50 years of case law, which has gotten very specific about the criteria in which they use to evaluate equality in facilities, equality in access, and everything when it comes to athletic facilities. Yet there is nothing that helps planning and zoning committees at a local level, when they're evaluating improvements for athletic fields, to consider Title IX implications. For example, they turfed the baseball field and added a lot of amenities for predominantly the boys' athletic curriculum, but there was not equal investment and upgrading of the facilities for the girls, which materially impacts practice time, availability, and inclement weather, et cetera. And it continues to go on, probably across the state, in terms of some of the liabilities or exposures that local towns have for Title IX claims to be made. And it's a very reactive system to something that's been a law for 50 years. For example, the state has now granted $4.5 million in funds to make improvements to the Broad River baseball fields and for other parks and recs. Now, this further, elaborates some of the discrepancies in terms of access for softball or for girls programs or all gendered programs. So I think that
3 minutes is up. Please summarize.
So basically, I'm just providing context that there's a host of liabilities that the state has, and to urge the committee to consider having all gender representation as well on the working group. Thank you very much for the opportunity.
Thank you, Ms. Knight, for your testimony. We appreciate it. And certainly, I'm sure that several of us could speak to the fact that we've seen this in our own districts. And I think a lot about the fact that the fields are not as well maintained, for instance, for field hockey. And so girls are more often injured than, say, the football players who are playing on a very well maintained and brand new field. Any questions? Thank you so much for your testimony today. Up next, we have Ilya D'Annunzio. And then on deck is Michael Winkler. I am not seeing Ilya. Mr. Winkler. Also not with us. Okay. Jeff Gentes or Gentes. Apologies if I slaughtered that.
Good morning. My name is Jeff Gentes. I'm an attorney with Connecticut Fair Housing Center and a clinician at Yale Law School. So thank you, Senator Rahman, Representative Capros DeGraw, Senator Fazio, Representative Zullo, and other members of the committee. Thank you for allowing me to testify today. I'm here in strong support of Senate Bill 916, which is a bill that would put some guardrails around sewer lien foreclosures. This bill, in one way or another, has come up in the prior two years. This is the mildest version of the proposal so far. It's from Senator Looney, and it is essentially would require that the bill be at least $4,000 in principal sewer liens before foreclosure started. And the reason is that there's a few reasons that this is a good idea. One is, when you start a foreclosure action, if it's a $500,000 house or it's a $2,000 sewer bill, the costs are principally the same in terms of what it takes to actually for the attorneys to do work, to get a marshal, to pay the court fees. And so it adds $2,500 and $3,000 or somewhere between $2,500 and $3,000 in total to that bill, which on $1,000 bill, and we have bills of even less than $1,000 that we've seen in the past year, can triple, quadruple the bill. Whereas on a mortgage foreclosure, it's, frankly, not as big of a deal and something that you can deal with on a 30-year or 40-year mortgage situation. There's also just alternative ways to collect sewer bills. You can still pursue traditional collection actions. You can still have liens on the property and get paid in a refinancing or a later sale. There's other ways to do it. And this practice is really limited to only a few of the WPCAs that are out there. At the same time, too, I understand that sewer liens have infrastructure and funding needs, but they're getting 18% on these back bills, which and foreclosing does not bring in more money than sitting back and waiting for that 18%, continuing until that ratepayer is able to pay off the bill. You've also, as a General Assembly, have expanded the ways that homeowners can use sort of emergency funds or state subsidized loans to pay off these liens, making it more likely that the WPCAs will be paid off thanks to your work expanding some CHAPA administered loan programs. I also just want to add got a late breaking email from a colleague. Kathy Flaherty just spoke about House Bill 6559. One of my colleagues at Connecticut Fair Housing Center is going to put in testimony in support of that bill as well. And we're in support of it as an organization. And with that, I'm happy to take any questions you might have on Senate Bill 916. Thanks.
Thank you very much for your testimony. Representative Dubitsky.
Thank you, Madam Chair, and thank you for coming in. Very much appreciate your testimony. I certainly understand the purpose of this bill, but as is very often the case, it appears to be geared towards larger municipalities, larger systems. How do you figure a small system with only a couple of dozen hookups is going to survive if all of the or any number of people essentially stop paying their bills? There's maintenance and upkeep that has to be done. Where is this money going to come from?
Yeah, I don't know that there's any reason to think that there's a difference in how a smaller system would handle this versus a large system. But even if I accept that that premise, it's still a matter of most municipalities are able to collect without foreclosure. So they can still file a collection action. You could still have wage garnishment, go after bank accounts, asset seizures, do everything else that you do. In addition to just maybe pointing people towards assistance programs and the like that then help them catch up. I have not met people who are sitting back and gaming the system by not paying their sewer bill. And with an 18% interest rate, it's just a really bad idea to do so. So I understand the concern, but I think it would be hypothetical and not actually borne out, especially given that, again, there's just so many WPCAs that are able to pull this off without foreclosure.
Well, I didn't suggest that people are gaming the system. I suggested that there are people who are not paying their bills. And all of the methods of collection that you just mentioned also have costs involved. You have to hire attorneys to do all that. Your argument seemed to be that it's costly to hire attorneys to do a foreclosure. Well, it's essentially the same cost to do a collection action. How is it saving any money by doing one over the other?
I just disagree. It's not. It's quite different to the foreclosure cost because of the need to do a title search. You have to go ahead and name everybody else in the complaint. The procedures are more extensive. The foreclosure action is more like another type of civil action, another type of And I apologize if I'm not looking in the right direction for you, Representative Dubisky, given the. this high-
That's quite all right. I, certainly understand in this world, you
Yeah.
never know where the camera is.
Gotcha. Well, you're here on a little TV for me to my left, so I'm gonna keep looking that way. So anyway, I just the collection action, I think it's a good alternative because it's in fact much cheaper. It's not cost free, but typically you can get those kinds of small claims collection bills and the like less than $1,000 in extra fees versus a foreclosure being 2,500 or 3,000.
Why wouldn't you just let the municipality decide?
Because there are some municipalities who have sort of abused government power by bringing foreclosure actions and jacking up bills for people with relatively small amounts. So I understand that there are some municipalities who are doing it the right way, and those folks would not be affected by this bill. And it's the ones who have been abusing the system. When you have 169 municipalities, and then you add several regional authorities on top of it, not every single one's going to be a great actor all the time on every single thing. So I think this bill would do a nice job of putting some guardrails around the ones who are sort of abusing the privilege. And it's something very serious when you deal with government power, taking somebody's home, threatening to foreclose. And for that reason, I would be happy to constrain municipal power. As much as that, this might not be the right committee to say that, but nevertheless.
Thank you very much.
All right, thanks.
Thank you, Madam Chair.
Representative Zullo.
Thank you, Madam Chair. I'm just curious if you have any data on what the average sewer bill is for, the average homeowner in the state. And not to put you on the spot, you may not have that, but do you?
We looked at this. We looked at this a couple of years ago, and we were scraping data to pull the bills that were sought. There were certainly less than 10% of the bills were higher than $4,000. And some of it is driven by Bridgeport, which is the Bridgeport Sewer Lien Authority is very aggressive, and most of the bills are $2,000 or less there. There were a couple others who drive most of the volume. So in terms of the average, I could look at the average bill in foreclosure and give you a sense of what that's like. I could pull, I think, I'm happy to follow up with the committee on just giving you a sense of, how much are people seeking.
I should have been clearer to it. I mean, when I'm saying average bill, I'm thinking either monthly or quarterly, because I know my bill and it's about $110. So what I'm trying to understand is what this proposal would say is that for me, for $4,000, you're saying it would be okay for me to not pay my bill for 9 years before somebody could start a foreclosure?
It's not okay. And you would be penalized at a rate of 18% for your unpaid bills. What we're saying is that right now authorities make the step towards foreclosure prematurely and drive up the bill. I think the issue that we deal with when we talk to homeowners, it's just they didn't realize that how much it costs on a foreclosure, and they're dealing with a host of other bills, and they tend to be people who are lower income, but maybe they'll still nevertheless are homeowners in one way or another, and are scrambling. And sometimes it's the mortgage company who comes in and pays the bill, but now then they have to deal with the mortgage company who just tacked on $4,000 over $1,000 in a sewer lien bill. So that's the issue. It's not okay. We're just simply saying if supporting this bill means foreclosure is not the appropriate remedy over an amount that's as small.
I'm just worried that I'm trying to understand how it's a cost savings going a collection route versus a foreclosure route, because you have a court entry fee, you have a service fee in both actions. You have hourly fees that are going to accrue in both actions. When somebody files an answer, somebody has to do a disclosure defense, et cetera, et cetera. You're going to have hourly fees to appear in court in both actions. You're then going to have hourly fees on a hearing and damages. You're then going to have marshal's fees as far as executions, if you're going to execute on a bank, at least in a collection action. So I'm trying to see where the cost savings is. And then in the end, you may end up in the same boat, because once you get a judgment, you can record a judgment lien and then you can foreclose on the judgment lien. So you may actually end up with more charges if you force towns to go the collection route. Do you see that as a potential?
No. I just disagree that the foreclosures they're more extensive because you're dealing with the title insurance. You're not dealing with it's a collection action. There's no one else to disclose a defense or to go after. You're not dealing with all the other sort of corporate entities that are named in a foreclosure that you have to go out and default. You're not dealing with the title search. You're not dealing with sorry for repeating myself. And in terms of a lien that's recorded after the fact, you know, our homestead exemption here on sort of non-consensual liens would arguably apply in that situation. And so it would prevent people who have, you know, amounts of less than $250,000 in equity from facing a foreclosure. So I just disagree on the costs. I mean, any sort of, you know, any kind of medical debt, any kind of like other kinds of collection debt that you see, they don't come with this extra $2,500, $3,000 in costs.
And then we heard a little bit about small systems, but collectively, I mean, sewerage systems, these kinds of infrastructure systems, they require significant maintenance. Do you see any threat that if these monies aren't coming in, that deferred maintenance on these systems could result in a public safety risk?
Because I mean, and I would point to like the authorities that aren't able to do this, then talk to somebody like MDC, who's able to maintain a water system. You know, we don't have sewage flowing on the streets of the MDC towns because they don't pursue foreclosures. There's just other ways to do it, and I think there's some. I think we've all dealt with like, you know, most of the time you pick up the phone, you talk to people in government, and they're helpful and they're great. But there's a few tyrants, or there's people who just don't realize the effect that their actions can have, and can have abused the power that, you know, government can give them. And we just don't think foreclosure is the right way to go about it. And I just don't have those kinds of concerns, even in the context of the pandemic. You take somebody like Greater New Haven WPCA, which had been a frequent filer from 2015 to 2020. In, you know, October of 2020, Senator Looney Ricks references in his testimony to some articles in the New Haven Independent about that authority doing its sewer lien foreclosures. And for now, those filings have stopped as a result of the pandemic, and I think some media coverage. We don't have you know, sewage issues in New Haven. I'm there twice a week. It's not hasn't turned into a environmental wasteland.
Okay. I'll definitely follow up, and I'm actually going to go take a look at some of the costs of both actions and do the math to see if that holds true. I agree, obviously, in a collection action, you're not going to see a title search and something like that. But I don't know that I agree that the costs in a collection action would be substantially less. And again, I mean, eventually it's going to have to be paid. And I do think you can get post-judgment. It's an interesting calculus. Would you be amenable, or would you think it would be advisable to also include a time limit? So maybe not necessarily, so 4,000 and or more than 3 years or 4 years or something like that, because, you know, in that case, I think I'd be a little more likely to see some value in this.
Yeah. So, okay. So with the extreme caveat that I hate, so if it was a bill that we went to legislators and say, hey, I would love if you'd like this idea, and you said, oh, that bill ought to be a law, I'd feel more comfortable negotiating it. But with Senator Looney involved, I don't feel super comfortable negotiating the bill. That being said, I think, you know, based on some of the comments that are out there, even if you cap it at a period of years, you're still dealing with relatively low amounts, you know, still less than $4,000. I understand there's concerns about the enforceability of the liens for how long that period is. So I'm less about the time period of I'm less enamored of the time period. It's like sort of once you hit a certain threshold of years, you can then start a foreclosure, than it is extending the enforceability of the lien itself. If the lien were enforceable for, you know, 25, 30 years, that might be a better way to accommodate those concerns than on the back end. And then just to your point about the collection costs, even if it was, somehow, even if you had an expensive collection case, you're still not taking the person's house. You're still not threatening with that. You're not sending them to the courthouse with, the needs to figure out, do I need to ask for time to make sure my kids finish out the school year? Am I going to have to, what do I need to do to refinance? And it's usually, robbing Peter to pay Paul in terms of their bills. They starve some other bills. They drive money onto their credit cards. They do something else in order to address the pending foreclosure action. So it's just the leverage that is wielded against a homeowner in foreclosure is just of a different nature than the collection actions. So, it's just another reason we're in support of 916.
I appreciate you referencing the statute of limitations. That was what I was getting at. And one of my concerns. There was a time when my sewer bill was a lot less, and some of those things definitely expire if they had to wait until the principal got to $4,000. And I appreciate that additional insight about potentially extending the period of enforceability. That's not a terrible idea. I feel like I've monopolized some time, so any other concerns I have, I'll take on offline. But thank you for coming today and for your testimony. And thank you, Madam.
Okay. Thank you for your, and for all the committee members and indulging attorney talk between the two of us, which is, hopefully we didn't get too into the weeds there. Thank you.
Any other questions? Senator Wong.
Thank you, Madam Chair. And I understand the good intentions of this bill. And you cited some of the bad actors and aggressive collections and foreclosures. I totally understand that. But it's also important to balance that the important funds that are needed to maintain infrastructure, sustainability, maintenance of our sewer system. So you've got that balancing act, right?
Sure.
But for me, what percentages are the $2,000 lien limit that you cited earlier of outstanding, collections from your experience? You cited a percentage of the $2,000.
Yeah. So I last looked at it in 2021, and if I were remote, I'd be able to do this seamlessly, and you wouldn't even know. But I think I just have to pull up what we did scrape, but it was, God. You're saying below $2,000 or below?
Yeah, I think you cited, I'm just listening to you. You said 6%.
No, yeah,
Less about $2,000. Less trying to get a better understanding.
No, yeah, I would less than 10% were greater than the $4,000 in this bill. And generally, if you're talking about a $4,000 bill going to sewer lien foreclosure, in these towns, it's generally of a commercial nature. Another thing that I could imagine making sense is if somebody, I saw this with a town recently. I was just dealing with a property that had been in the owners had passed away, and there were a collection of property taxes and sewer lien bills. Now, granted, some municipalities that the two are one and the same, where the sewer lien is run essentially by the town, but they were foreclosing for property taxes and sewer lien bills that, were well north of $4,000, even if the sewer lien bills themselves were less than $4,000. And that to me was okay, because, there was another bill on top of it to sort of justify the total amount being foreclosed was worthwhile. And then there's other situations where if somebody owes property taxes, there's nothing wrong with a WPCA and the town filing a joint action as well. So that, maybe even if you got somebody who owes a few years worth of sewer lien bills, but it's pretty far backed up, but they often owe property taxes as well. And so kind of combining those two, and I'm really maybe I'm responding to Representative Zullo, another way to harmonize the sort of competing interests of wanting funds now versus the cost of the foreclosure action. That's another way to dull the impact of a foreclosure.
If I may, if you have the analysis or tracking that you could provide this committee, I think that would be very helpful.
Sure.
I think having some experience in this, I think the original of this bill 2 or 3 years ago was a $10,000 limit. And through the good work of Representative Zullo, the chairs, as well as former Senator Champagne, who has a municipal leader, offer some insight and the good working dynamics we have in the Senate with Senator Looney. We reduced it to 4, and that was a rationale on ability to pay and also the length of time in regards to accruement of these overdue money. What's the objection to possibly even setting the limit at 2,000?
We're just talking about proportionality. It's a matter of if the foreclosure itself, I mean, I guess I would say this. Starting from a baseline of, I'm coming here to support this specific bill from Senator Looney. Or up to me, we just wouldn't do foreclosures over amounts this small at all. And so there wouldn't, $10,000 was awesome, and even higher amounts. But that being said, I think it's just a matter of, okay, at what point do you need to threaten to take someone's home and drag them into Superior Court through a full-blown court action over, what's the bill limit that you're comfortable with? And so the $2,000 that happens all the time. I still think doubling a bill based on, and money that just goes to the attorneys, right? It's not going to the WPCAs. Don't get the money. They just get it a little bit sooner. And the sooner they get it, the less likely they are to collect the 18%, right? Like the less they actually, so, 2,000 to me is just too low. But it's kind of a question on, it's really as like policymakers, what you're comfortable with.
I appreciate that. And I appreciate your honesty in saying that you prefer there were no foreclosures at all. And I think that goes up against the balance that we have in maintaining a viable and sustainable sewer system, which does cost money. And it's an important public service and public health service. So there is a balancing line. And I'm curious with the percentages that you get. We want to get the aggressive bad actors in our municipalities that go after when there is no limit and threshold. But the fact is, we're not looking to kind of punish people that are arrear because of economics or current pandemic restrictions that impact their ability to pay, and compounding the foreclosure issues and mortgage. I understand that, but wouldn't it be fair to have a threshold of kind of accountability and to prevent the bad actors and looking at $2,000 or a number that could be calculated to be fair and equitable, but also have a measuring point? I mean, your initial preference and preference stated is you prefer to have no foreclosure action. Then what happens? What happens when people in their struggles make a decision that they can't pay that? Who's footing the bill for that infrastructure maintenance?
Yeah, so I think there's also there are a few different things happening. So one is besides the other mechanisms of enforcement that we mentioned, and you could extend out the lien enforceability period. There's also this, to the extent that these essentially government actors could go out and bond, right? They would be able to raise money even with the transaction expenses and well exceed the 18% that they're not getting. That's one thing you could do, is put these other unpaid bills, or be able to just say, listen, here's what we collect in revenue. And even if we're not able to pay you with existing cash flow, we get 18% on our receivables and are able to pay you. And I believe that the municipality bonding percentages right now are well below, 18% and even lower. And I might feel differently too if we weren't at 18%. There's been other proposals in the legislature that we also think are good ideas that, until starting in the 60s, the rate on unpaid property taxes and that sort of assessment rate was at like 6-7%. And then as interest rates climbed through the 70s and up until 1982, that's what the interest rates were more or less following prime. And then at 18% in 1980, I think it stopped. And it's never come down since, right? So, and the idea was like, we don't want people to game the system by not paying a bill and getting more in the S&L market through S&L investments or their savings accounts. So I get that too. And if the 18% came down to a level that didn't make, then there'd be a different set of trade-offs as well even with these sewer lien authorities.
And I appreciate that. And it goes back to this conversation about balance, right?
Mhm.
And accountability. But I also know that in this committee, we did do some very good work in looking at that 18% penalty and reducing it and kind of doing an incremental basis. I think that's an important point of consideration. But then ultimately, it's a loss of revenue to our municipalities, and that's the balancing act that we have. But you raise a very important point that if we look at a smaller amount of 2,000 and we reduce the penalty that as a result of day one, it's multiplied by 18, it's a significant penalty. Maybe those are points of consideration that I would encourage that your organization and many others that are advocating for this to also advocate to like that, 10,000 is too much, 4,000 may be too much to be able to collect and enforce funds to sustain an important public service. But maybe to not penalize people at 18% if they fail to meet the deadline on day one. That's a thought, just a thought. But I appreciate your time and thoughts and the good work that your organization does. Thank you,
Thanks.
Madam Chair.
If I could just, for one other component of this is the people that we do see who there are different, different demographics of people fall into different boxes with, who's in foreclosure and who's not. And there are differences amongst municipalities among who's in foreclosure. We tend to find with property tax foreclosures and sewer lien foreclosures, it's disproportionately older Black homeowners who are cash poor, but have some equity to foreclose on and maybe have paid off a mortgage, maybe been in the house for decades. And that's just disproportionately so. Not everyone, obviously not across the board, but that's something that we see in our practices, and it's pernicious given the towns. I listed 5, but it's primarily it was Bridgeport that's filing the bulk of the foreclosures in 2022, and up until 2 years ago, the Greater New Haven's WPCA. Sorry, Representative Delnicki.
Representative Delnicki.
Thank you, Madam Chair. This bill also addresses third-party assignment. And I know a couple of years ago, we actually established rules of the road for third-party assignment. And last year, there was a push to reduce the 18% down to 12% for third-party assignment. So it strikes me that conceivably you would be precluding third-party assignment, yet there's an opportunity where it could actually be a better deal for the person that finds himself in the rears. What's your opinion on that?
I was with you up until the very end. So somebody we're precluding someone from, right. There's the cap is on assignments. You wouldn't assign the bills until $4,000 had been hit. I'm sorry, if you could you repeat your question?
Again, the question is real simple.
Okay.
Are you in agreement that third-party assignment should be precluded in this bill? As proposed, as written?
Well, I guess the alternative is if they weren't covered by the bill, then the towns could just assign them off at amounts that were less than $4,000. And then you'd end up with all the sort of, I guess you're saying because we now have guardrails around the third party buyers,
right?
It would be, yeah. So I think it's okay. So with the third party buyers, yes, in 2021, there were a lot more guardrails put around people who purchased property tax liens, sewer liens, which a growing number of municipalities are engaged in. I would still rather have the municipalities and the authorities, to the extent that they're democratically accountable, be the ones who are actually foreclosing or collecting from their residents directly, notwithstanding. I view the collection piece of it mostly as like a way to put a lid on a practice that may not be a great idea in the first place. I don't know if I'm.
So let me ask a follow-up question.
Yeah.
A municipality, unless they pass an ordinance, has to charge 18% interest.
Right.
They have that option. They could actually pass the ordinance and they could actually charge a lower interest rate, correct?
Right.
But if they don't do that, and there are guardrails on a third-party assignment, wouldn't that offer an opportunity to the property owner, the person that has the lien filed against them, to have a chance to actually dig themselves out from underneath the 18% interest rate that would occur
Yeah.
at a lower interest rate? Plus, wouldn't it also afford the homeowner, the property owner, the opportunity to negotiate something with the third-party assignee?
Okay, so yeah, I'm following with you. I think though, those guardrails that are around third-party assignees are not superior to sort of what already protections you may have against the municipality. I mean, there were sort of like contracts like, hey, you have to have somebody to contact at this third party. They have to, if you ask them for, hey, how much this is my bill, they have to get back to you. It's like in the same way that, a tax collector would have to get back to you. Or somebody at the WPCA would have to get back to you. I don't know that there's so much more additive than what the town would already do. And our experience with those third-party buyers is that they don't negotiate at all on the 18% on the fees they think they can charge. And they do it based on, and even when you negotiate with them, or even when you go to court and point out, hey, here are the excess charges, and they fix them, they'll still try to charge you the attorney's fees for fixing their overcharges. So I don't have I understand the point. And if you're saying, if we paired, instead of for the assignments, we took an approach of lowering the interest rate from 18 to 12%. That might be a nice alternative. And then you're telling the towns you could either sit and wait, or you could sell this off to a third party buyer who can't collect 80%. I'd have to think about that.
Let me ask another follow-up question.
Sure.
A town can send out as many dunning letters as they wish from an attorney, from the town's town attorney.
Yep.
And a town could actually receive a sum of money for the cost of that legal correspondence, correct?
Right.
So the third party assignee has a limit on the number of letters they can actually send out, the value of them, so as not to gin up the cost to the homeowner, the property owner, whoever that has the lien.
Yeah.
And do you see any advantage in that, in allowing the third party assignment?
I think what happens with the third party assignment ends up being that they're perfectly happy to sit back and wait and collect that high interest rate before they start a foreclosure. So they're actually not pursuing the lien until they've sort of gobbled up all the equity that they think is safe to collect, so that they're not sending the same number of dunning letters. I hear what you're saying. I just think in practice, they actually sit back. Yeah, they sit back, they wait, they have the super priority of collecting 18%. Even if at 12%, they'd sit back and wait. They got a secured investment, and they're not looking to pursue. They're looking to let that investment grow before they actually go out and collect it.
But the town would find itself in the same position of sitting back, correct?
Right.
So either way, the third party assignee, if we were at 12%, would have more of a stake in settling the claim or settling the debt.
To an extent, I mean, they're still in it to make, they're looking at it like less about, they're thinking, they're not thinking at all about the revenues and maintaining the WPCA. They're thinking about, can we eat up the equity? And can we then, before we start a foreclosure action?
Because I know from experience, the town's collectibles on sewer liens are typically valued significantly above what the actual value is, based on the fact that there's interest being collected at 18%.
Yeah.
So it almost seems that it becomes more attractive for a town to collect the 18% interest than a third-party assignment, yet the third-party assignment could very well be more advantageous.
Yeah, maybe.
And that's being precluded in this bill.
Yeah, I think it would have to be paired with at a minimum, like a reduction in interest that the third party could collect, I think, in order to have that, in order for the trade-off to work.
Well, thank you for your comments and answers there. And thank you, Madam Chair.
Just to close out
Sure.
with a question of my own. I think I know the answer to this, but I just want to, for my edification, who is the primary beneficiary of these sewer lien foreclosures?
The attorneys who represent the authorities.
So in terms of them being the primary beneficiary, I mean, you know, if we weren't going to go this route with the 4,000, is the next best route lowering that interest? Is that, you know, I believe you said there are other ways for them to collect, which speaks to, if there's other ways for them to collect, then I'm not sure the maintenance of the infrastructure is actually as pertinent an issue if there are other ways for them to collect.
Right.
Not entirely sure there's a question in that second part, but you know, is there a better way for us to be going about this perhaps than the $4,000?
I think there's some authorities, for whatever reason. I think no matter, even if your interest rate were at 12% or 10% or 8%, I'm saying, I think in the past years, I think then Representative Camillo had a bill, now is he first selectman in Greenwich? It was at 8%. There's been bills in more recent years around 12. Those would all be helpful. I don't think it would change the practices of some of the most abusive WPCAs, because either way, they're not benefiting from whatever the interest rate is. They're just sort of or they're not thinking about it. They're just saying, we're moving to foreclosure relatively quickly. But I think both proposals are worthwhile. Does that work?
Okay, thank you very much. And thank you for your testimony
All
today.
right.
I don't see any other questions at this time.
All right. Thank you so much.
Next up, we have Jason Klein, please. And on deck is Dorian Famiglietti.
Good morning, everyone. For the record, my name is Jason Klein. I am here as the chair of the Connecticut Bar Association's Planning and Zoning section. I'm also a partner at the law firm of Carmody, Torrance, Sandak, and Hennessy. My practice is primarily out of our Stamford office, but we have offices across the state. I'm here today to speak in favor of Bill number 915 concerning a zoning board of appeals, or a ZBA, as I'll refer to it in my testimony, a ZBA's authority to review variance applications. I encourage you all to vote for this bill, subject to some modest modifications that myself and my colleagues on the ZBA would recommend. As you heard from Attorney Shansky earlier this morning, the current statute really has an adverse impact on families and small businesses who may need modest relief from their local zoning regulations. But there are other folks who are impacted by their current statutory regime. The written testimony that myself and Attorney Famiglietti, who you'll hear from, points out the adverse impact on the volunteers who serve on our local ZBAs. The statute forces these volunteers to make a choice, a tough choice. One, do you follow the letter of the law and deny almost every application that comes before you, no matter how reasonable, no matter how beneficial the application will be? Or do you ignore the law and approve reasonable and worthy and positively impactful projects? We think, and I think, that a law that forces that choice upon a volunteer serving their community is evidence of a broken system. The good news is that we can change that. And the bill that's before you today is an important step in that direction. I think the bill has two really positive and important factors that break away from our current broken system. And I'm happy to go into greater detail about each of these, improvements if you have questions for me. The first is to make a clear distinction between a use variance, or a variance from a rule that limits how you can use your property, from an area variance, a variance from a rule that governs how you can build or improve a home or a structure that's on your property. There will be no change to how a ZBA can review a use variance. Historically, use variances are seen as having a greater potential for adverse impact. Think someone who's trying to build an auto repair shop in a single family neighborhood. That would be an example of a use variance. An area variance, on the other hand, would be, a family who's expecting, maybe a new kid in the family or welcoming an aging parent or relative into their home who wants to make a modest addition to their property. Their local rules might say your home has to be 25 feet away from your rear lot line. But this addition might require them to build out so that their home is 22 feet away from the rear lot line, a 3-foot difference, but
Your
still
3 minutes
requires
is
a
up.
variance.
Please summarize.
And that variance would have to be denied under the current law. Perfect example of why this should be changed. We have a lot of support, and I'm happy to take any questions that y'all have. And thank you for the opportunity.
One quick one from me before we get to Representative Dubitzky. Do you think that this is going to in any way impact or weaken local zoning, in your view of the bill?
No, I don't think it's going to weaken local zoning in any way whatsoever. If anything, it's going to result, I think, in a more predictable, more equitable administration of zoning at the local level. Right now we have local officials who, and it's not their fault. The current statute is very difficult to understand. It's very inaccessible, and it results in countless, I would say, bad zoning outcomes. Can prohibit the preservation of historic buildings, can prohibit environmental compliance or ADA compliance. These are things that, local folks want to see, improved upon at the local level. There won't be any, reduction in local authority or autonomy as a result of this bill.
Okay, thank you. Senator Fazio.
Thank you for your testimony. You mentioned at the end that this wouldn't affect use variances. Can you clarify what you meant? Because the bill does have language on use variances.
Sure, certainly. And thank you for the question, Senator Fazio. The bill as it's written does change the format of the language applicable to use variances. And what I mean by that, the current statute, section 8-6, the current standard is called the unusual hardship standard. And it's one, run-on sentence that, you'll have to read 3 or 4 times before you figure out, half of what it says. So I think what the bill does is it breaks down that language in a way that's just more accessible for a non-attorney to read. At least that's the intent of the use variance component. But a use variance will still have to prove, to be clear, in order to be approved, the hardship standard, the higher level of review. There's no change to that. And again, that's because there's a general understanding that those variances, and I think it's common sense, that could be more harmful than a house that's a little bit closer to the backyard than most.
And is this the litany of standards for the use and area variances? Is this being, you're telling the municipalities, the ZBAs, that this is what they have to follow, not that they have the option, but this is the standard, the new standard that they have to follow across the state?
Yeah, interestingly, there may be many ZBAs who are not telling them anything new, because the factors are very similar to the analysis that they engage in today. Because the current standard is so inaccessible, a lot of ZBA members will sit there and say, well, what are the pros and what are the cons? And they will weigh those out. I will tell you, and as a member of the Bar Association, this is something that we've been working on for several years. We started in the fall and winter of 2019. We were going to have a hearing in March 2020, and then things changed, right? Things changed. So we've been looking at this for a while, and we are open to ideas from other folks. You yourself, I know the American Planner, the APA, the Planners Association, and zoning enforcement officials have thoughts on, are these factors the right factors? Are there too few? Are there too many? And we're open to figuring out what the right factors are for ZBAs. But to be clear, there are many boards that are engaging in this very analysis today. And if they weren't, they wouldn't be able to approve hardly any variances.
Yeah, but just to be clear, the bill as is does impose these new rules on use and area variances on all ZBAs across the state.
Yes, it provides guidance to ZBAs that don't have any today. That's correct.
And I get the listen, I get the intentions too. Certainly. I also wonder and am concerned that it's putting a lot more responsibility and power in the hands of ZBAs in comparison to zoning boards,
Mm.
which traditionally would do the heavy lifting.
Mm.
Now, because you're opening up so much to appeal, it's almost like, I don't want to use the word gutting, but you're significantly eroding the use and application of zoning, which is kind of like, you're equally applying things, standard across certain zones in your municipality. And you're giving so much latitude for appeal that you're going to be putting all this burden on what, as you pointed out, these volunteers on the ZBAs, and almost all the town's planning and zoning is going to be done through appeal rather than the traditional, standardized method of zoning.
Yeah, that's a great question. And I think, you're right. So there's the zoning commissioner, the planning and zoning commission, and then there's the zoning board of appeals in many towns, right? And I think what some folks would say, and what I hear folks tell both myself and my clients sometimes, is don't apply for a variance. Maybe you should change the zoning regulations. And I'll tell you what, for a big, regional or regional or national developer, that's a perfectly rational and available solution to put together a comprehensive package petition to a town to amend their zoning regulations to allow for a bigger building or a different type of building. It's an application that is fairly expensive. It's an application that takes a lot of time and research, and often not just a lawyer, but a traffic consultant, an architect, a soil scientist, a civil engineer. That's not available to most folks who seek variances. In my experience, going before various ZBAs here in Connecticut, it's a family that's looking to get a variance. It's a small business that's been in the community for generations. Those are the folks who are getting variances or seeking variances, and they just don't have the wherewithal or the ability to go through their zoning commission to petition for a regulation amendment.
Yeah. I just worry this becomes one off after one off after one off, and it becomes so voluminous. I also, listen, there's a subjective quality of a lot of these standards. And so obviously there's going to be disputes even after ZBAs issue their decision. How do you view these? Listen, I'm assuming you'd agree that it's difficult to pin down how you fit, how you meet these qualifications, and reasonable people are going to disagree on, thousands of these decisions by ZBAs. What happens then?
Well, again, and maybe I believe this is in the written testimony, and maybe I didn't say it earlier this morning, that the legislation is not intended to make it any easier or any harder to either approve a variance or to deny a variance. Its intention is to bring some order and some predictability to an arena of the law that is devoid of that in many communities. I can't say that, we think as lawyers, as folks who file these applications, and as folks who bring appeals to Superior Court, we think that this will have a tendency to reduce litigation rather than result in more litigation. So I think that that won't be a concern should this bill come to pass, become law.
All right. Thank you, Madam Chair.
Thank you, Representative Dubitsky.
Thank you, Madam Chair, and thank you for coming in. I was listening very intently on your discussion. You couple of things. First off, you said that this isn't intended to make it easier or harder to get a variance. But at the beginning of your statement, you essentially said it is trying to make it easier to get a variance. Could you explain which one it is?
If I said that that is not the intent of this legislation. It is not the intent of this legislation to make it easier to get a variance. The intent of this legislation, I guess if it's going to be easier on anybody, it's going to make life somewhat easier for folks who serve on ZBAs, who now will have clear guidance and a better ability to understand how to do their job.
All right. Well, here's my concern. the way it's set up, you've got the zoning commission, which essentially is, you know, doing it in lawyer talk, is the trial court that takes the applications, reviews all the evidence, listens to the witnesses, the applicant, the soil scientist, the engineer, the traffic engineer, you know, all listens to all these people, has the ability and expertise to look at all these things and make some type of determination. And then if they've made a wrong determination, or if there is a legal issue with regard to a hardship, then they go to ZBA, who only looks at the record. I'm concerned that without some guardrails of some sort, this is essentially just making a second zoning commission with a second look at a second trial court with a second new application, because when the zoning commission is balancing all these considerations, including comment by the public, etc. Now you're moving into the ZBA, which is supposed to just look at the law, and they are also going to be weighing all these various competing considerations. Who's to say that the ZBA is going to be right and the planning and the zoning commission was wrong?
You know, typically, just as a point of clarification, most folks, it's not that there'll be an application to the P and Z commission and then they go and get a variance. That's not how it works in every community. But as I mentioned before, when Senator Fazio, mentioned the role of zoning commissions, many of the folks, I would say near maybe north of 90% that go to their ZBA can't afford to make the application necessary to their planning and zoning commission to amend a zoning regulation. And I think if the concern is, well, this statute will result in disregard of the law and disorder in land use, that's what we have right now. We have disregard for existing law. We have disregard for folks who are just trying to make a reasonable use of the home they grew up in, or make a reasonable use of the business that they've been building for decades or generations. That's really the main thrust here.
Well, they would typically have to go to the zoning commission anyway, even if they get a variance.
Not always, and typically your variance would be, in my experience, you petition for your variance, and if you're approved, you can often go ahead and just get your building permit and build your project if you're lucky to get your approval. On the other hand, what you have, and I realize I'm looking at myself here, I'll look up, I'm sorry. On the other hand, what you have in the Planning and Zoning Commission is an applicant can bring an application to amend the zoning regulations. And if that amendment is successful, then bring a site plan or a special permit application to their zoning commission to build the project envisioned by the regulation amendment. Those are sort of the two main paths, I'll say, on the zoning road. And typically it's a institution or organization with more financial ability that can go the regulation amendment route.
Okay, well, I can certainly see this with regard to something like building a dormer on a house, putting in a shed or something like that. But, how do you ensure that this isn't used to essentially circumvent the Planning and Zoning Commission, and just go and get an approval directly from the Zoning Board of Appeals with regard to major commercial operations, things that otherwise would not make it through the Planning and Zoning Commissions. For example, you can get a variance to say, like, let's say somebody says, well, I don't want to spend the money to get a special permit. I'm going to go to the ZBA and get a variance that I don't need a special permit.
Yeah, no, I think that's a good question. And you know, I would say in that instance, a special permit is more akin to a variance application. So I think someone who can afford, you know, who may be able to afford to bring one, may be able to bring the other. So I don't know that you'll have folks dodging in that capacity. What I tell you is, you know, what will your sort of the start of your question was, you know, what controls a ZBA from approving bad variances. I think the factors in the variance or in the area variance analysis would prevent that. For example, and this is, I'm looking down and referring to my written testimony that I co-signed with Attorney Famigletti, who you'll hear from later. One of the first factors that we would suggest ZBAs analyze in the area variance application is determining whether the proposal is consistent with the physical site characteristics of the neighborhood. So if you have a business who's looking to build a 5-story building in a downtown that's made up of 2- and 3-story buildings, I'd say that's a variance there's a good case to be made under the bill, as we suggest it's amended. There's a good case for that variance to be denied. Also, the second standard or whether there's some feasible alternative that doesn't require a variance. That's a factor that I would say would probably limit the abuse of the area variance tool.
Those seem like they are inherent functions of the Planning and Zoning Commission as opposed to a ZBA. That balancing and that, you know, taking of evidence. But I appreciate your testimony, and we will certainly consider it. Thank you.
Thank you.
Thank you, Madam Chair.
Thank you, Representative. Senator Fazio for the second time.
Thank you for the indulgence. Following on Representative Dubitsky's question, was it ever contemplated or has it been contemplated with regard to this proposal to place a limitation on the size of the property, the value of the property, so that, as you say, if it's just, you know, Jane and Joe or a very small business looking for this sort of consideration, rather than, you know, a major development or a major project of sorts, was that sort of considered you know, a type of limitation on this process?
Yeah, you know, that's an interesting question, and I'll say again, you know, I personally, for whatever my personal and professional opinion is worth, I'm open to hearing other ideas as to what factors should or shouldn't be considered. I think that's terrific, and we should have an open mind about that. I would say that, and again, I'm referring to my letter, that factor where that, you know, a variance has to be consistent with a town's plan of conservation and development. I think that may have the effect of, you know, preventing major, you know, substantial developments from using taking advantage, not my words, but just assuming, you know, assuming taking the ZBA route. And what I mean by that is, you know, towns issue their comprehensive 10-year plans every so often. And if there's a project that's really out of scale with the plan of conservation and development, the area variance analysis would say, ZBA, you shouldn't grant that. Whether there's a way to, you know, provide some sort of financial affidavit or something to prohibit, you know, folks with more money, you know, or bigger projects from even filing an application. I don't know that we can do that, but I think the factors that are in the statute would prevent substantial projects that are out of step with a community or a community's plan.
Thank you. Thank you, Mr. Klein, for your testimony.
Great.
Have a great day.
Thanks so much, everyone. Appreciate the time.
Up next, we have Dorian Famiglietti, followed by Jeff Lemay.
Good afternoon. Thank you for the opportunity to the committee members to be heard on Raise Bill 915. I am Dory Famigletti. I am a land use attorney who's been practicing out of Vernon, Connecticut for 26 years. I am the immediate past chair of the Planning and Zoning section of the Connecticut Bar Association, as Jason just referenced. And I also am in support of this bill. And I think you heard a good discussion from both Jason Klein and Marjorie Shansky on what the proposed law changes. And I think it's equally important to discuss what's not going to change. Because I think we all have to recognize that some of you and some potential opponents to the bill may have some trepidation about making a change to the formal standard governing variances. So I think it's important to recognize that the principle that the variance power should be exercised sparingly and only under exceptional circumstances will remain unaffected. We do not plan to change the ample case law that stands for the proposition that variance power should be carefully exercised in a limited fashion. That will remain the same. And the principle that great caution should be used in granting variances, for without that caution, the whole fabric of town-wide or citywide zoning will be worn through until its purpose of protecting property values and securing orderly development would be completely thwarted. That principle will remain unchanged as well. This is not an open book to mandate ZBAs to start granting more variances. It's just a way to work with what has become an unworkable legal requirement now under the general hardship rule to allow variances to be granted and also then be defensible in court. Another thing that will not change is that the idea that the proper way to deal with regulations that are consistently found to be too restrictive is by way of a regulation amendment, that will remain unchanged as well. So if a town sees an unusual amount of variances being requested to deal with a common problem, that should still trigger a discussion and review by the town as to whether the underlying regulation should be changed. But in the meantime, why be forced to deny a variance under the existing rigid structure and make the property owner wait out the process of amending the regulations? That property owner's business or personal interests could be greatly impacted in the meantime. And if a balancing of the equities doesn't justify it, then why be forced under the current standard to deny the relief being sought? Now, it's been said, and there's been concern referenced that this will make it easier to get a variance. And with that, I don't agree, because from a practical standpoint, a similar balancing is being conducted today by most jurisdictions anyway. I do believe that this legislation is merely—
Summarize.
Yes, thank you. We do believe this legislation merely codifies what many jurisdictions are doing right now. It doesn't necessarily make it easier. It's a balance, and I think it allows the ZBAs to do exactly what they're charged to do, which is to be a mechanism to provide relief when circumstances warrant it. Thank you. And if you have any questions, I'd be happy to answer them.
Thank you so much for your testimony. Seeing no questions, have a great day. Number 12, Jeff Lemay, please.
Hi, can everybody hear me okay?
We're good.
Yep.
Go ahead.
All right, great. Thank you so much. Thank you so much, Madam Chair, and thank you for members of the Planning and Development Committee for listening to me here. My name is Jeff Lemay. I work for the town of South Windsor as a wastewater treatment plant supervisor. However, I'm not here speaking for the town of South Windsor. I'll be speaking for the Connecticut Water Environment Association. I'm the vice president of that organization and also the legislative chair. And I'm here to talk about Raise Bill 916. Obviously, there's also already been a fair amount of discussion on that, and I appreciate it. Some of the stuff that's already been gone over, I won't bore you with again. But essentially, we've been in opposition to this bill over the last couple of years. I can see, obviously, that the that $10,000 threshold has gone down to $4,000, and we were certainly happy to see that. I just wanted to speak to some of the challenges that we see with this. So it was brought up, is really the issue is as it pertains to the sewer user fees. An assessment can reach that threshold very quickly, as can a connection. But the average sewer user fee in Connecticut is in the neighborhood of, let's say, I think it's around $500 or so a year. So at that rate, at $4,000, you're still looking at 8 years of not having to pay the bill before that foreclosure can be an option. So I just wanted to bring that up. And for municipalities where it's not a flat rate, but it's based on water usage, those bills can be very low and it can take even longer to reach that threshold. So I just wanted to point that out. With costs of goods and services up considerably, it's already really a challenge to try to keep rates flat, which I think most municipalities have been trying to do with COVID and the economic impact over the last few years. But for when there are more people that elect not to pay that bill because they don't have to in that instance, in that moment, that has to be taken into consideration when setting the rates for the following year. So I feel like it's going to negatively impact the ratepayers who are paying their bill. And I just want to point out too that a lot of those ratepayers are also people that might be struggling, but they're still choosing to pay that bill and making that effort to do that. And it's negatively impacting them. And the rates can potentially have to go up to make up for the folks that aren't paying. I also want to stress, we don't want to foreclose on homes, right? It's not in our best interest to. We work with people all the time. I know that here in South Windsor, there's payment plans. I believe that there's some opportunities for people that are in difficult situations for, just easier or you have to excuse me, I'm a little nervous here. But there are opportunities to make those in multiple payments.
Please summarize.
Sorry. So I just wanted to point all that out. And basically, people not paying the bills can also affect the town's bond rating. And we're really just trying to keep things stable. And I also just want to add lastly, that for some communities, people not paying is more of an issue than it is in others, depending on how many people are on the sewer system. Thank you very much.
Thank you for your testimony.
Thank you.
Senator Fazio.
So again, the statistic you cited was an average sewer bill of $500 per year in Connecticut. So the simple math on that would be that this would not allow significant recourse. This proposal will not allow significant recourse for the average customer in Connecticut until they miss payments for 8 years. That's what you were saying, correct?
Yeah, and I'm sorry if I don't have that exact number. I just remember that the flat rate average was in the neighborhood of $500 or so there. Yes, yes.
Thank you for your testimony.
You're welcome. Thank you.
Again, seeing no questions. Thank you so much. Have a wonderful day.
Thank you all very much. I appreciate your time.
Number 14, Ben Shaken, followed by Megan Miles.
Good afternoon. Thank you, Madam Chair, members of the committee. My name is Ben Shaken. I'm the Director of Government Relations at the Connecticut Community Nonprofit Alliance. We are the statewide trade association for Connecticut's community nonprofits who serve 500,000 people across the state every year. I'm here to testify in support of House Bill 6559 with a suggested amendment, the same one that Ms. Flaherty made earlier. In short, the bill would repeal discriminatory state statutes that make it difficult for nonprofit providers to open new programs serving people with disabilities of all kinds in residential settings across the state. First, just let me say it's great to be back in person in a public hearing. I'm very glad to be here and see all of you. Connecticut's community-based system of care, which is delivered almost universally by community nonprofits across the state, it really relies on the ability for programs to be located across Connecticut, fully integrated within every city and town. And people with disabilities of all kinds also deserve the right to be afforded the same rights as everybody else, to live wherever they choose and not to be discriminated against. Unfortunately, as Ms. Flaherty said earlier, state law currently allows for discriminatory practices to occur in municipalities in the state. You have my written testimony, so let me just sort of focus on how this works in practice. and how the state statutes that exist are discriminatory. First, they are on their face. There's spacing restrictions in statute, and they serve really no other purpose other than to limit the number of people with disabilities in communities across the state. I'm not an attorney, so I'm going to try to avoid sort of a legal analysis, but there's no government purpose behind the existence of these spacing restrictions. The only purpose that they serve is to limit how many people with disabilities can be served in residential programs in a particular location or municipality. Secondly, they do have discriminatory effects too. So even in places where if a nonprofit had to go get a special permit to open a residential program, a community residence in a place, and that permit was granted, that community was very friendly, the zoning commission, the public, et cetera. The mere existence of these statutes is a higher burden than you and I would have if we wanted to purchase a home, that you and I would have if we wanted to have our family members and maybe other people's family members with disabilities live in that home. And so forcing a group home to go get special approval to open compared to a different home that would have an otherwise conforming use of that particular piece of property has a negative effect on the creation of new residences for people with disabilities, as do the provisions of statute that this bill would repeal that allow for any individual citizen to file an official petition with a state agency to revoke the license of one of these facilities solely because they allege that the facility has violated any state statute, as long as they get the permission of the mayor of that town. One of the weirder provisions of state statute.
Your
I've
3
never
minutes
seen
is
it
up.
before.
Please summarize.
Thank you. So in summary, I'll just say we agree with Ms. Flaherty's request for the amendment of the definition that the draft bill has, and I'm happy to take any questions, but we really appreciate the committee raising the bill and hope you'll support it. Thank you.
Thank you, and thank you for your testimony. Seeing no questions, have a good day.
Thank you.
Up next, we have Megan Miles.
Hi, good afternoon. At this point, my name is Megan Miles. I am a partner at the law firm of Carmody, Torrance, Sandak, and Hennessy. I'm a land use partner, and I am based in our New Haven office. For a little bit of background, I've been practicing land use law about 10 years. In Connecticut, I started out as a clerk at the appellate court, actually handling land use petitions for certification. And then I entered private practice and have been representing primarily applicants on land use matters, mostly in the western part of the state, in Stamford, New Haven, Danbury, Waterbury, Milford. And I did submit written testimony, so I'm not going to restate it. I'm actually going to be a little off the cuff because the benefit of being, I'm actually speaking in support of 2 bills today, by the way. I'm speaking in support of, it is SB 915, which is modifying section 8.6 concerning variances. You've already heard some testimony on that. And I'm also speaking in support of SB 918, which is modifying 22A-105 concerning coastal site plans. I don't know if that gives me 6 minutes, but I will, does not. Okay. So, just about variances real quick. The reason you've had a string of lawyers before you on this variance bill is because what we're trying to say is that the Zoning Board of Appeals is granted the authority to issue variances. The problem is that under current law, they can't. They are hamstrung under the current standard to issue variances because it's almost legally impossible to establish a legal hardship. What has happened over the decades is that we've established various strategies for homeowners to make reasonable improvements to their properties. Not just homeowners, I'm sorry, property owners in general to make reasonable improvements to their properties. Often it's to preserve a historic structure or for coastal resiliency reasons on the shoreline or building code. There's various strategies they can do. One is we can tell our clients, you really have a great case here. Your neighbors like it. Go to the Zoning Board of Appeals, get a variance, hope you don't get appealed. That's one path. The other is that they apply for a text. We say, you know what, amend the zoning regulations themselves. When you amend the zoning regulations, that is a legislative act by the Planning and Zoning Commission. That is extremely hard to reverse on appeal. So when you You go to the Planning and Zoning Commission, you say, listen, we have this old home here on the water, we want to lift it. The Planning and Zoning Commission says, we want to encourage that. Yes, let's amend the zoning regulations. What has happened is that the town has made a change that affects an entire zone. Now, every single property in that zone can do what really should only been done for one site on a case by case basis. Or the alternative is what the town has really just done is benefited one property owner in a way that doesn't conform to the comprehensive plan, which is now encourage spot zoning in the neighborhood. So that is why what is before you, I think we've actually suggested, the planning and zoning suggestion has suggested some slight modifications to the standard, but really it's a standard that sets a workable framework, a strict standard to meet, to actually issue variances so that the zoning board of appeals can do their job, really. So that's regarding variances. I also don't want to let
This is up, please summarize.
coastal site plan. The current process is redundant on the shoreline because when you often have to get multiple permits, you have to bring a coastal site plan in each stage. And the problem is that, so I actually just had this happen with a local health clinic, and they needed parking relief first. And then they needed to go later for certain site plan special permits. They needed a fully engineered site plan with stormwater, which can cost up to $15,000 at their first step, which was a parking variance, not a variance, a parking special exception. If they didn't get that, they weren't going to do the project, but they had to invest potentially up to $15,000 in site work that would have been superfluous. So I think I think it's honestly an oversight, and this is a great fix.
Thank you very
Thank
much for your
you.
testimony. Representative Zullo.
Thank you, Madam Chair. You kind of got to that second point, which I just wanted to make sure that you were going to get to, but my question was going to be, do you believe that this is going to save applicant costs and also reduce administrative expense and time? And I think you answered yes, but go ahead.
Absolutely. So I've had this problem most often in New Haven, and it's a situation where the engineering department and the planning staff are reviewing a coastal site plan in connection with the variance. They're requiring all these materials that really aren't necessary in connection with like a parking special exception or something like that. Often the site plan slightly changes, very slightly, and when you move on to general site plan review or special permits, and they're forced to completely redo the review, and their prior review is now obsolete and they have to do it again. So if it's just at the final stage of permitting where you have your final project site plan, or really just the final relief you need, it seems like the most efficient process.
Perfect. I appreciate the clarification. I don't have any other questions.
Yeah.
And I appreciate you lending your expertise today. Thank you. And thank you, Madam Chair.
Thank you. Representative Dubitsky. Sorry, Representative Dubitsky. Representative Delnicki.
I was like,
how long have we been sitting here?
Thank you. Thank you, Madam Chair.
Thank you.
So I have a scenario for you on 915, the variance by zoning boards.
Yes.
A property owner that abuts a residential area, and they want to have a truck terminal.
Yes.
Planning and zoning rejects it. They go to the zoning board of appeals and based on an area exemption asks for that. What recourse does the residential area have?
So two responses. First, a truck terminal would be considered a use under zoning. So it's use as a truck terminal. The current bill does not change the current standard for use variances. So a truck terminal would still need to meet the current legal hardship standard. Also, you mentioned how, they went before the Planning and Zoning Commission first and they lost. So that it's extremely unlikely that would happen because the Zoning Board of Appeals does not review P and Z commission actions on appeal. So the ZBA only reviews on appeal decisions by the zoning enforcement officer. So for example, if the zoning enforcement officer went out to the site and tried to shut down an illegal truck hauling operation, then that would go on appeal to the ZBA and they would be able to assess whether the zoning enforcement officer was right. If they lost, they would ask for a variance, but so a truck terminal would still be held to the current hardship standard. Also, you reminded me of a point I neglected to make, is that variance applications almost always require neighbor notices. And so neighbors, either abutters or with 100 feet or 200 feet, will receive notice that this application is pending, be given information on how to appear at a public hearing. And so they can go and express their concerns and the zoning board of appeals can hear that. If the truck terminal decided to amend the zoning regulations to permit truck terminals in this zone, there's no neighbor notices for that. So that can be significantly more under the radar. So that's just an aside as well, but a truck terminal is a use.
So taking into account the fact that, say, the property were in two different zoning,
It abuts a
zones,
residential zone. Yeah.
and it was a warehouse.
Currently.
Now, a situation like that, and they don't even bother to go to planning and zoning. They just go right to the zoning board of appeals because they saw
They
the
should do
previous
that
scenario
first.
that we
Yeah.
discussed here. They saw the individual failed on that. And now they want to do something, but they realize that they probably have a better chance going to the zoning board of appeals and going for a change to allow them to have a warehouse. So how would that scenario play out? And quite frankly, and I'm not looking to make any comments about the folks that serve on the zoning board of appeals versus planning and zoning, but they're two different types of appointments. You know, one's an appointment and one's an elected body. And typically the planning and zoning commission would be an elected body, and typically the zoning board of appeals would be an appointed body.
Mhm.
So how does that shake out?
So trying to unpack your question here, so a warehouse wants to change into a truck terminal or something like that. It's assuming it's not permitted in the zone. They have two paths to do that. One is they can go for a variance. The other is a text amendment. So what I'm saying today is that they're not going to go for a variance. They're not going to go to the ZBA under current law because they're not going to get a variance to operate as a truck terminal next to a residential zone. There's no hardship. So they're not going to. They're going to go to the zoning board. They're going to go. I'm sorry. Now I'm confusing the terms. They're going to go to the Planning and Zoning Commission to request to amend the zoning regulations. There's not going to be neighbor notices, but the Planning and Zoning Commission does have their own standards they have to follow to grant text amendments. It has to be in accordance with the comprehensive plan, that sort of thing. So today, if that's what someone wanted to do, they're going to go try to change the text of the zoning regulations to permit truck terminals. What this legislation does, or what this amendment does for variances, is I don't think it changes anything because a use variance still requires a hardship. So if a client came to us and said, you know, I want to operate a truck terminal here, the situation hasn't changed under this legislation. I don't know why I'm pointing behind me, but it hasn't changed under the legislation because it does not change the current law for use variances. If to change your hypothetical a little bit and say they could operate as a truck terminal under the current zoning regulations, but they want to be able to park trucks closer to the property line with residential. So they want to put trucks closer when now they couldn't. That would be an area variance. And so that would be a circumstance where they could assess, you know, do they want to try to change the zoning regulations entirely for parking standards abutting residential zones? Or do they want to try for a variance here and whether they meet these very specific area standards? So looking at the language here, it's a 1, 2, 3, 4, 5, 6, 7, 8 prong analysis to perform about whether there really has been an adverse impact on the neighborhood. So, I mean, candidly, that's a really tough sell. Permitting trucks to park, it's tough. but they would still have to meet this 8-prong standard, which includes such variance will not adversely affect the character of the neighborhood or any nearby property. Such variance will not adversely affect physical and environmental conditions of this such neighborhood. So I don't think that this bill presents the circumstance where now a truck terminal can very easily get a variance to park trucks next to residential zones. Rather, it just gives the ZBAs a lot more in their toolbox to assess, and probably under those circumstances, come up with a laundry list of reasons of why it shouldn't be granted under those circumstances.
Well, I thank you for your answer, but I still have concerns over the fact that it's an area variance as opposed to a use variance, a very specific variance. Because you could have a situation where actions are taken this year for something that we want to do next year. And it would seem, for lack of a better term, innocent and could actually be used to put something in an area that really shouldn't be there. And that's my concern to this concept here.
I think this legislation is not, what this legislation is intended to do, is my understanding, is allow ZBAs to issue variances under appropriate circumstances that do not adversely impact their neighbors and not risk an appeal and litigation costs. It really gives them the legal basis to issue variances when they should appropriately issue, because they're supported by the neighborhood, they're supported by the municipality, rather than motivating either cheating, where someone just does it and it's on the zoning enforcement officer to police it, or a zoning text amendment entirely, which can have a more profound impact on the community. I don't think this makes it any easier to issue variances. It just gives significant guardrails and standards to follow, because right now, when no one can meet a standard, it's just people are trying to find workarounds to it. So this sets a standard that can be followed and allows ZBAs to actually do their job and issue variances under appropriate circumstances.
Well, I thank you for your testimony, and thank you, Madam Chair.
Thank you, Representative Del Nicky. Thank you so much for your testimony. We see no other questions at this time.
Okay, thank you.
Up next, we have Bryce Chanot, followed by David Kluski, I'm going to guess.
Thank you, Madam Chair, and members of the committee, for the opportunity to testify here today before the Planning and Development Committee in support of HB 5796, an act requiring public comment periods at public agency meetings. This is actually my first time having an opportunity to testify here in Connecticut, and as a new resident of Newtown, it was great to see Senator Wong here earlier today. My name is Bryce Chanot, although I appreciate the French pronunciation before as well, and I am the Director of External Affairs at Yankee Institute. Yankee Institute is a public policy organization here in Hartford that is dedicated to bringing transparency to the policymaking process. Yankee Institute supports HB 5796 because it empowers the public to engage with policymakers, will bring further transparency to government actions, and increases the likelihood that state and local governing bodies will consider all the effects of a policy may have throughout Connecticut. HB 5796 empowers the public by ensuring that everyone can formally express their support or opposition to a policy or proposed reform. This change would encourage everyday people to pay closer attention to state and local government, as they would have a clear avenue to voice their opinion. We regularly receive questions from our supporters across the Constitution state about how they can make their voices heard, and this reform gives them the opportunity they are looking for. As a result of empowering the general public, actions taken by state and local governments will be more transparent. If more community members engage in the policymaking process, the greater the likelihood will be that details of legislation and regulations will be better understood by the public. Government officials will also be more likely to respond to real constituent concerns. With a more empowered general public and more transparent governing bodies, state and local governments will be less likely to adopt harmful policies. If a new regulation will drastically increase the costs of doing business, threatening employment and economic vitality, the public will be able to formally engage in that rulemaking process to stop the change. Residents of a town will be able to push back on unwanted zoning reforms that were discussed here at length, or encourage changes in our police forces and fire departments. Parents will be able to challenge potentially harmful changes at our public schools or improve community center programs as well. Those are just a few examples, and the list of potential benefits is at least as numerous as the topics regulated by our state and local governments. With this change, Connecticut could join a number of other states that ensure the right to participate in public meetings. I actually included a link in my written testimony from an organization that provides that across the country. And thank you again for the opportunity to testify in support of HB 5796. I hope this serves as a just very modest example of how we can all benefit from allowing the public to testify at public meetings, along with everyone else that has testified here today. I also, as I have just a few seconds left, wanted to express our support as well for HB 6557 on the tangible personal property tax exemption. It's very small, but it does help in some way for business owners.
Thank you so much, and thank you for your testimony. I'm going to start off with a few questions myself. I have to say, I think that we encourage in all of our communities quite a lot of public comment. I think that, in fact, Connecticut is one of the few states that has such a broadly open capital in which people are able to engage with their legislators, other elected officials. What are the states around us? Is this, common practice in the states around us for all meetings?
Yeah, that's a great question. I don't know the extent of it thoroughly throughout the other states. I had a chance to review a number of other state statutes that have it. I know states like California, diverse states too, like California, Hawaii, Arizona, Nebraska, Louisiana, Florida. So it just runs the gamut of regionality and politics have particular requirements that there is this opportunity for the public to provide oral testimony, but it does vary by state. Some do not. There's, I think there seems to be a lot of de facto that, but not necessarily de jure.
Additionally, because you did bring up parental rights issues around perhaps Board of Ed meetings, and we have had Board of Ed meetings that have ended in fistfights in the state of Connecticut, in addition to across the country. I think, my question would be, at what point does this become sort of injurious to the process? Because we certainly have people who are not happy with their 3 minutes, and they want it to be 3 minutes on every single topic, or as even today, while you were testifying on 2 bills, you still had to get that within your 3 minute, mark, so to speak. So I guess my concern would be, this going sort of overboard in terms of allowing communication.
Yeah, thank you for the question and for all of your questions. It's a very good one, and it is very difficult. But I think I would err to the side for government. It isn't a burden on government to provide transparency and opportunity for engagement. It's a requirement. It's a necessary part of our open dialogue in a democratic republic. So the legislation, as I understand it, definitely leaves some level of variance to the local town committee to set up their own rules and parameters, and that's good, because like here, if I'm coming here to testify, it's actually very difficult to schedule a day, right? So I think it was 16th on the docket, but I really don't know how long that's going to allow me the opportunity to be here. So it's setting parameters can help the public be able to better engage it. They'll roughly know when they'll be able to voice their opinion. There is a risk of it going the other way, but I think allowing a decisive avenue for people to do it at the local level, I think mitigates that effect, because if you think that there's no opportunity in order for you to informally do this, you're probably more likely to take adverse actions that inhibit all public policy discourse.
Yeah, I think that everyone in this room agrees with transparency. I mean, we certainly, do as much as we can, and have left so many options in place for people to testify. So I think that moving forward, obviously more transparency is often better, and leaving it up to the towns to decide how they want to interact is probably for the best. I do see a question from Senator Wong.
Thank you, Madam Chair. And it's a good example of the new Zoom world and hybrid world we live in. I was in person and now into multiple meetings. Thank you to the Yankee Institute for being here and spending your time being involved. I think it's an important part of participatory democracy. And we've had 2.5 years where there's certain restrictions to it. So it's great to see you in person. I have a question specific in regards to, okay, we want to require public comment period, but one of the most important parts of that is information and transparency and knowing about these meetings. One of the things that we've considered in many times is public notification requirements through newspapers and how we are moving to a more digital form. But I also hear that not everybody gets access to a computer like we have the privilege here at the General Assembly. Could you offer some thoughts on that in regards to if this bill was to be passed and afford people public commentary at all meetings? What if they don't know about the meetings or know about these issues because we're not transparently making that aware to them? Because we have requirements in the General Assembly that I believe bills need to be posted 5 days, and bill language needs to be at a certain time requirement. But would you look at this bill and certain requirements of transparency and reporting so people can know when they can testify or when they can speak up on issues? Any thoughts on that?
Yeah, that's a great question, Senator. And what would be a best solution to ensuring people can have access to it? I don't necessarily know the answer. I actually just picked up a copy of the Newtown Bee this morning while I was at the general store. And there are often references to public meetings on there. And I know the CT.gov regularly posts them on theirs. I think any effort to do that is beneficial. I don't know what specifically towns and the state could do offhand. I'd be happy to follow up on that question. But I know as someone, I worked in the policymaking realm down in Washington, D.C. for years, and federal agencies would require that they post a 30-day comment period on all hearings. Now, they didn't necessarily provide for oral testimony at all of those hearings, but I think something like that is very helpful. As someone that's following the legislative process here in Connecticut in detail for the first time, it is awfully difficult to, there's something in the ballpark of 3,000 bills or something, or 2,500 bills on the docket already. And, the time from when a posting of a bill is made available and then the opportunity to come and provide testimony is very narrow, at least from my perspective. So expanding that, I think, would be a good thing. And I'd be happy to follow up with the committee on specific ideas that we could use to expand that.
I would appreciate that. And I think the open access creates opportunities, but as the good chair mentioned earlier, it can get a little bit unyielding and it gets to a point of diminishing returns. So I think it's a great idea. I think it opens up the commitment to transparency and public accountability on issues. But the idea that there may be controversial issues where, and I know Yankee Institute believes in a balance between government and individual rights, there's some times where government thinks it knows better than the general public. And it's important to have the general public voice their concerns and engage in a participatory government, that it is not a good policy. So I appreciate that the Yankee Institute and yourself make the time to testify in this. I also want to acknowledge the two committee members of Planning and Development, Representative Tawazowski and Representative Baumgarten, in supporting this bill as a bipartisan effort of transparency and accountability. So thank you to Yankee Institute, and thank you, Madam Chair.
Thank you.
Thank you, Senator.
Representative Baumgartner.
Yes, and thank you, Bryce, for coming out to testify on this important bill. As was shared in many public testimony that I've read this morning, it is very clear that many municipalities have had issues with, or residents in our municipalities have had issues with providing public comment during their council meetings, especially in meetings where those respective regulatory bodies, whether it be council or planning and zoning, are making very significant decisions that will impact the communities for years to come. And there has not been opportunities for those residents to provide testimony and allow policymakers to really take into account their suggestions and concerns. So I appreciate you taking the time to testify in support of this bill. Obviously, the bill it's far from the end of the legislative session, so it will go through many phases. But my question to you is, do you believe there should be a minimum or a cap as far as the amount of minutes an individual may have to as their public for public comment or public testimony. And do you believe there should be a different set of regulations as far as public testimony from the public and from by residents? Do you believe we should treat municipalities differently than all public agencies, which would include obviously agencies within or meetings within the state of Connecticut for the state of Connecticut?
Yeah, great question. And again, I don't know that I'd have a specific for any one particular instance, but say, for instance, I was in charge, I was working on the team at a Board of Education on how we would better structure this. I would probably review what other towns in our state are doing, and then I would review what comparable size towns or something that's of comparable size and scope has, and how that has how it has worked there or not worked well. And then I would take in and try to incorporate the lessons learned by others. I think the structure that's here at the assembly where you dedicated 3 minutes is definitely great. It requires you to be on point and precise in what you're doing with it, and having it germane to a particular agenda, I think is a good parameter to guardrails to set up. But if I was in charge of doing that at a local committee, I would look to other committees that have examples of it and learn from their successes and failures.
Thank you.
Representative Zawistowski.
Thank you, Madam Chair, and you did get it absolutely on point this time.
Working on it.
Very good. Anyway, I'd like to thank you for coming in and testifying on this today. I know you and I have had some conversations on what some of the practices might be. And I know that most of our municipalities do allow for public comments, and a lot of them at both the beginning and the end of meetings. So this is certainly not intended to browbeat our municipalities. There are some that do not, though, and this is something that would provide the opportunity for the public to chime in on things. And I know that the chair had mentioned situations where you might have had some altercations about different topics that have been brought up. I mean, are you of the opinion that this would actually be a pressure valve versus, as far as making sure that everybody had an equal opportunity to speak? Or in that situation, would you try to avoid having public discourse?
Yeah, what that question has reminded me of is I've spent time the last decade. I've been in the Washington D.C. area, and to say that there are political rallies and opportunities for comment by the public that get very intense and engaged down there is to say the least. And when I've just overheard and observed people that have gone to say protest an event talking about a regulatory policy thing that they disagree with, what I've often heard is that if you don't give us a seat at the table, you can expect us to shout you down and to yell and demean. And now as much as I disagree with that as an approach to policy solving, I think something like a requirement that, and you give an avenue to people it's a manifestation of our fundamental rights, First Amendment, free speech, and ability to engage with the government. This is a clear path to do so. I think it can release some of that tension. Is I know I'm going to have my opportunity in front of this commission or board to express my thoughts. And I'm going to make the most of that opportunity. That would be my hope I think the intent behind the legislation. And I would imagine that it would have a successful effect here in Connecticut.
Thank you, and thank you for being here and testifying in favor of 2 bills today.
Yeah.
Thank you, and thank you, Madam Chair.
Thank you. And seeing no other questions, thanks so much for your testimony.
Thank you very much, Madam Chair.
David Kluski, number 17, and James Perito is on deck.
Yes, good afternoon, Senator Rahman, Representative Cavos DeGraw, and other distinguished members of the Planning and Development Committee. My name is David Kluski. I am tax collector for the town of Fairfield, as well as chair for the legislative committee for the Connecticut Tax Collectors Association. As an association, we are opposed to raise Bill 916, an act concerning foreclosure, assignment, and other enforcement actions for unpaid sewer assessments, fees, and charges. as it's currently written. We support its intent, but we request changes to its language, including further clarification on line 1, section 1, line 28 regarding the meaning of prohibiting the action of enforcing payment is needed. Does this also prohibit from us demanding payment or even just accepting payments if voluntarily offered? If a municipality is already foreclosing for another reason, such as delinquent property taxes, must the sewer debt be excluded? As you know, sewer charges are direct expenses for municipalities for the usage and maintenance of sewer systems. This legislation effectively makes the first $4,000 of sewer charges purely optional. What is in this legislation to prevent from making payments under $4,000 optional? Will the state compensate municipalities for the huge proportion of revenue, which would now be unrecoverable? In summary, the threat of foreclosure, we as tax collectors, we don't want to go through this process, but the threat of foreclosure is what encourages on-time payments. Just some numbers to kind of piggyback on what Mr. LeMay was saying out of South Windsor. Here in Fairfield, almost 50% of our 16,000 accounts, so over 8,000 accounts of sewer use are under $300. And a bill of $300, that's going to take 13 years to achieve $4,000. We're only allowed to collect for a period of 15 years. So again, we support having protections in place before any enforcement action is taken. However, we request that the balance limit of $4,000 be revised and instead be based on amount of years delinquent. We believe that sewer use charges are often based on water consumption, as in the case in Fairfield here. So we believe that the foreclosure action should be measured by an individual's level of failure to pay rather than the amount of water they've consumed. So again, in summary, like I said, we believe it should be based on the amount of time, not the amount of dollars. And again, we are opposed to this legislation, but we appreciate and support its intent and just request the changes to the language. Thank you.
Thank you for your testimony. Seeing no questions, have a wonderful day.
Thank you.
James Perito, please.
Thank you, Madam Chair and members of the Planning and Development Committee. I thank you for the opportunity to speak in favor of Raise Bill 915, an act concerning the granting of variances by ZBAs. My name is Jim Perito. I am an attorney at Halloran Sage in New Haven, and I live in Branford. In the past 37 years, I've practiced primarily law in real estate and land use. I've had the privilege of representing municipalities, both large and small, homeowners, developers, commercial property owners, and people opposed to development. And I'm currently on the legislative committee of the CBA's Planning and Zoning section, which has been the proponent of this legislation before you. I also like to echo Attorney Shansky's testimony this morning, and I view, as she does, that the variance is a zoning tool that's part of the entire zoning regulation fabric. And when that was enacted in the 50s, we didn't have regulations for wetlands. We had very few building, fire, and health codes. We didn't have the ADA. We didn't have FEMA. These are all regulations that over time have put more regulations on property owners. And at the same time, what's happened is the zoning variance tool, which is sort of a safety valve to allow some flexibility, has essentially been eliminated by virtue of the case law. It's very difficult to get any kind of variance. Our hope with this legislation was to restore that tool for the ZBA in certain instances that would, as enumerated in the proposed legislation. And I know that my section has some suggested changes to sort of tighten that up. Two quick examples that actually happened. We have a restaurant in one of our towns. They got through COVID. They had to downscale their size of the restaurant. They got able to relocate to a smaller site, a few blocks down from where they were, but they had to do changes to the hood and the internal restaurant sections. That necessitated external changes, and they needed a variance. Fortunately, no one was in opposition, and the ZBA granted it. But from a legal standpoint, it was not a legal variance. There was no basis in hardship. Everybody wanted this, and it was reasonable what they were asking for. Another situation, family needs to take care of an elderly relative. They need to put in a ramp. The ramp can only be in a side yard. That's a structure. They needed a variance. Again, no legal hardship. they were granted the variance. But what this legislation would do for allow for those circumstances, not all of them, but some of them, and the ZBA still is weighing all these factors and making a determination, but it would allow that homeowner and that property owner, that business to obtain a legally sustainable variance for them. I wanted to address one other point as well on this, is that what I've seen in my practice is that from an equity standpoint, many small businesses and property owners in less affluent areas in our state and our towns, they can't afford to hire a lawyer that makes the record to support their hardship request. So they're not able to get it. And I see that time and time again. So when you hear some of the concerns about, someone coming in to get any kind of a variance, that's not this legislation. That was never the tool that was the variance. Our committee did look at New York.
3 minutes is up. Please summarize.
Thank you. We looked at New York, Massachusetts, and Rhode Island. They've instituted these kind of changes and it's working for them. So we urge you to adopt this legislation. Thank you for your time. I appreciate it.
Thank you for your time and your testimony. I have one question from Representative Lamar.
Yes, sir.
Good to see you, Jim. Thank you so much for your testimony today. A couple of questions. I'm glad you referenced other states. Would you suggest that the language that's submitted in this bill is similar to that which exists in those states that you referenced?
We modeled a lot of the language, and again, the section has made some suggested changes because somewhere along the translation things get changed, but that language is modeled to look at the kinds of categories for the ZBA to look at. So yes, we looked at their language and tried to structure it from there, with our differences in Connecticut based on our law.
Do you appreciate, there's an argument that I've heard earlier today that suggested this would open up municipalities, zoning board of appeals to increase litigation by the somewhat arbitrary decisions that the opponents feel that this may allow zoning boards to make, not based on strict hardship definitions, that the decisions may seem somewhat arbitrary. Are you concerned about the fact that there may be more legal exposure for municipalities when they allow variances that don't meet the traditional hardship standard that has been in practice in the past few decades?
My answer is no. I think, in fact, the opposite will happen. I think that this legislation will support in those instances where a ZBA wants to grant the variance, but the applicant really can't make the hardship standard. It gives them steps that they can go through, an analysis they can go through, standards to look at that justify the granting of a variance, which makes any court appeal ultimately not successful. Now, under the current situation, everyone may be well-meaning, the applicant, the ZBA, there's no legal hardship, and for some reason, someone brings an appeal and the municipality incurs those costs and most likely will lose that appeal.
Terrific. Thank you. I generally, I'm torn on this issue. I kind of understand the need for it, and I kind of understand the equity concerns associated with it. I served on my local, as you know, I think you had a number of issues before me, but in the day, I served on the New Haven Board of Zoning Appeals and also the New Haven City Planning Commission, and oftentimes was able to recognize how much more favorable those decisions were made when applicants were represented by attorneys that we had comfort and familiarity with and understood the processes by which we were making our determinations. And if you did not have that experience and exposure or representation, oftentimes you couldn't meet the legal standards that we were forced to operate under. But at the same time, I am concerned about the lack of uniformity in decision-making and whether or not different privileged individuals may receive different consideration by not meeting a more coherent and structured and legal standard. So I'm going to look at this one quite closely and hopefully I can reach an internal resolution, but I do appreciate the advice and thought that you've put into this. Thank you.
Thank you.
Senator Fazio.
Thank you for your testimony, sir. I wanted to ask a question that I asked another proponent of the bill, which is that, was there any consideration to kind of delimiting who these appeals are eligible to, size of the property, et cetera, and whether the appeals for use would be whether there was any discussion to limit that to say, limit that to avoid converting, say, residential use to commercial use. Any of those considerations in the process?
Yes, first of all, I think that some of the suggested changes to the raised bill by the section were meant to clarify which was originally put forward, which is that this was not a change to the use variance standard whatsoever. Most municipalities have, it's not just even hardship, there's some other steps they put into that. And we agree that the use variance standard should still be very stringent and very difficult to get, because we don't advocate that someone who wants to put an industrial use in a residential zone comes in and gets a variance. That's not the process. They should change the regulations if they want, and that's a whole other process, but that's not the ZBA. So I agree with you. To the extent the bill needs to be tightened to make sure that isn't interpreted that way, it should be. In terms of, I guess the other part of your question was
the area. Yeah.
Area. I mean, the area, we sort of viewed, because we talked about this, with someone who wants to, for instance, increase the density of, in a residential zone, they want to increase density to have more residential units in there, and they come in for an area variance, which this legislation in theory, would do. But in reality, that's a use variance, because you're trying to change what might be a single family residential area to multifamily by doing that. So again, that was not the intention. And I think that if language needs to be put in to limit that, then that should, that can happen. Also, I think about this is, a step to restore the tool. It doesn't necessarily mean that we won't have to take other steps as this evolves. It's like with any legislation, you try to think of everything, and we're trying to make the first step to sort of rectify what's happened over these many decades.
Thank you.
Thank you.
Representative Chafee.
Madam Chair, thank you for testifying with us today. Do you have any idea how often is a variance challenge in court?
Representative, I don't have any numbers on that. I just know from my own experience that much of it depends on, like in a neighborhood, how people are getting along. Unfortunately, I've seen that often in shorefront communities that, people are it's very difficult to get something minor. People are somewhat to be more litigious. I don't see that as much, frankly, in the larger municipalities. And usually those are situations where people are looking to help to benefit the neighborhood. And if it's reasonable, they don't appeal it.
Okay, so you'd say it's fairly uncommon?
No, I can't say in all towns, because I just know the towns I deal with that one town, people appeal all the decisions, it seems, and other towns 50% of the time or so.
I don't know how long you've been listening to the testimony today, but there have been a few others who have spoken in support of this bill, and they seem to be in agreement that if this were to become law, it would decrease litigation. Do you agree with that opinion?
I do. I think that the decisions of the ZBA that would be based, if they're inclined to grant the variance, the decision of the ZBA based on the standards we've tried to put forward with this legislation would give a decision that is much more sustainable. And I think that would discourage people from bringing appeals. That, someone would come in and talk to a lawyer and say, well, they made this decision. The lawyer would probably say, well, they've met all the standards here, and it's going to be difficult to overturn it. So they won't bring it.
Okay. I'm going to try to be very diplomatic with this question, but I guess I'm just curious why attorneys would be advocating for something that seems to be taking work away from them. I don't know if that's a fair characterization of what this is going to do, but go ahead. Sorry.
Yeah, I can only speak for myself. The reason many of us attorneys who went forward with this is that we see zoning boards essentially making decisions which are not in accordance with the law. And when I represent a municipality, I want my agencies, my zoning agencies to be acting in accordance with the law. They can't under the current standard. If the law was changed as proposed, then they're acting in accordance with the law. And many of them, I mean, they want to be acting in accordance with the law. The circumstances dictate it's legitimate to actually grant the variance. It's just that the hardship standard can't apply in these kind of situations. So we've tried to put in place something that will allow our municipal clients to be acting within the law.
Okay, thank you very much. Thank you, Madam Chair.
Representative Zullo.
Thank you, Madam Chair. Just to follow up on, I was trying to explain it a bit earlier, and I think I've had some time to think about it a bit. So one of my concerns with this is that, is specifically with the issue of area. So again, I get if you come in and you want to put a fence up and you need a little extra room in your setback. I see where the current standard can work a bit of an injustice. My concern is specifically with respect to area, with like lot coverage. Do you see a proposal like this potentially, or I see a proposal like this potentially leading to overcrowding, development on smaller lots that really aren't suitable for development, but now might be opened up for development because the standard is now changed where it's a cost benefit analysis rather than the undue hardship? Do you see any potential for that at all in this, if this proposal goes forward?
To the extent that a requested area variance does not change what might be the use from a single family to a multifamily, or even if you're a multifamily that allows only so many per, so many units per acre. I think that if it was granted to allow that, then that's going to be an issue. And maybe there's a way to limit that in the language. You can't use it to that. But in and of itself, area, I don't necessarily see that as being like sort of opening the doors to more intense development.
Because that's really what my concern is with this, is making sure that we don't have an unexpected consequence of more intense development where we don't want it. There's less of a threat of that when it comes to the setbacks and things like that. And again, I think it addresses those situations where you have a small community and you need to build a deck and you don't quite have the setback, or you need to do a pool and you don't quite have the setback, whatever it is. It's the area, that specific, the lot coverage that strikes me. And I'm going to think about those comments you just made about, as far as, the potential for more dense development. I'm not putting words in your, I know that's not what you said, but in that realm, because that's what I'm trying to hash through as I try to figure out whether or not this is a proposal that can work. But I appreciate that follow-up. So thank you. And thank you, Madam Chair.
Thank you.
Thank you. Seeing no other questions at this time, thank you very much for your testimony. Paula Perlman, followed by Ian Thomas.
Good afternoon, Madam Chair and members of the Planning and Development Committee. My name is Paula Perlman. I'm a staff attorney with the Freedom of Information Commission. I'm here today to testify on House Bill 5796, requiring that all public agencies provide members of the public with an opportunity to present oral testimony on any item appearing on any meeting agenda. The FOI Commission supports public participation in public meetings. However, the Commission has concerns with the proposal as written. First, the proposal does not define the phrase oral testimony. It's unclear whether the intent is to allow sworn testimony under oath or simply public comment. The phrase should be defined. Second, the proposal is overly broad and would apply to all public agencies and all public meetings. The Commission does not believe that allowing oral testimony or public comment at every meeting of all public agencies is appropriate. For example, it wouldn't be appropriate to require adjudicatory bodies like the Commission that conduct evidentiary hearings, which constitute public meetings under the FOI Act, and then have full Commission meetings to decide whether to adopt individual hearing officer reports to allow oral testimony or public comment. Only the parties to those proceedings are participants. If the bill is intended to apply to certain public agencies, we suggest that the proposal be narrowed to reflect such intention. In addition, it will likely result in the filing of additional complaints with the Commission. Under existing law, the Commission doesn't have jurisdiction over complaints concerning public testimony or public comment. If this proposal passes, the Commission would then have jurisdiction and would be required to adjudicate all these complaints. The Commission would be happy to work with the Planning and Development Committee on narrowing this proposal to help achieve its intended purpose and to ensure the greatest transparency and accountability. So thank you.
Thank you very much. And you win the award for the most brief and concise testimony. So thank you. Seeing no questions. Oh, sorry, Representative Baumgartner.
My apologies, and thank you, Madam Chair, and thank you so much for coming to testify and your service to our state. Obviously, your commission does very important work to ensure that the public does have the ability to participate in our democratic processes and really being the safeguard of public information and disclosure of public information that ought to be made for public consumption. So thank you again. Just briefly, you shared about some of the issues with the existing legislation as it is written and offering to narrow kind of its scope. My question to you, though, considering that this bill obviously is before us, and there has been testimony provided by the public regarding a perceived lack of ability to provide testimony to some of their respective municipal bodies. Are there any tools that you can offer them in the case that they are unable to provide testimony? What tools do those residents have to be able to express those concerns in a public manner if they are restricted from doing so at their council meetings where deliberations are taking place on important matters of concern?
Well, I think, our concern is more with respect to adjudicatory bodies where it's just participants in those proceedings that would have a voice in it. With respect to non-adjudicatory bodies, I think that you could legislate requiring public comment, but I think you would really, in our opinion, you would have to narrow what entities those would be. I don't know if it would be appropriate to have members of the public commenting on, zoning board of appeals where it's specific to certain parties, or to tax assessment appeals where it's the interest or of the individual who are appealing their tax assessment. Excuse me. But I think if you have like a local board or commission, you could allow for public comment, but perhaps at the end set certain time limits on it, or reasonable time limits, make it consistent across the board. Like here today, everyone had 3 minutes, and if there were questions, you had more time allocated to the testimony. So I'm not sure if that answers your question.
Yes, it does a bit. And then as far as the ability to engage in discourse or clarify questions that or seek clarification on issues or concerns a resident has brought forth to a municipal body. In Groton, for example, we used to have, as part of municipal proceedings, a response to citizens petitions. At the beginning of every council meeting, there's the opportunity for the public to provide written testimony on any matter, whether it's on the agenda or not. Up to 5 minutes, residents speak. And for many years, councilors had the ability to speak on what those residents shared with the group and actually allow councilors to weigh in. And there was a lot of noise and fuss made that it would somehow be a violation of the Freedom of Information Act, because then councilors would risk violating the FOI statute for reasons unbeknownst to me. But this has been some of the guidance that has been made to the council bodies. And the council recently did away with the response to citizens petitions through the rules change processes. So now councilors are not even able to speak to the concerns that residents are bringing up. And so I just can't fathom how that would be a violation of our Freedom of Information Act, when for years that was common practice. So can you speak to some of those issues?
I'm not quite sure what it is that they had concerns about. If it was a matter on the agenda, then the council member would be able to discuss it. If it wasn't a matter on the agenda, but you had a separate agenda item for public comment and you didn't limit that, it's already on the agenda. So I don't see why the members couldn't speak to that, because it's still an item on the agenda. the more concerning is if the council members stepped aside into the hall and they had a discussion.
Of course.
So I can see that as a concern, but I believe as long as there's some item on the agenda, then there could be raised at the meeting. So I'm not sure what was happening.
So in
in the
your
town.
eye, is it unconstitutional to restrict a counselor's ability to respond to citizens petitions? Is that a violation? Let's walk that back. Is it, would it violate the Freedom of Information Act to respond to citizens petitions, whether something is on the agenda or not?
If it's not on the agenda, we wouldn't be able to, council members couldn't discuss the matter. It has to be open to the public, but if they could always add an item to the agenda.
And so if it is on the agenda, based off of how the Freedom of Information Act is written, counselors would be able to provide responses to citizens petitions on a matter that is germane to the discussion by virtue of an issue being on the agenda.
I don't see why under the FOI Act, they wouldn't be able to do so. Perhaps there's some separate statutory, some other statute that would prohibit it, but if looking specifically at the FOI Act, I don't know what would prohibit them from
And if-
addressing a concern.
And if there is an issue that with the state statute that does prohibit it, it is my hope that if should this legislation proceed, that issue is tackled with this legislation as well. And again, I want to thank you for your indulgence and your time as well. Thank you.
Thank you, Representative Zullo.
Thank you, Madam Chair, and thank you for your testimony so far. So what I'm hearing is that if the proposal were to be refined to simply provide that opportunities for public comment shall be provided at all meetings of the legislative body of each respective municipality in the state, would that be more palatable insofar as, and maybe even further with the limitation and to the extent that those meetings are not held for any adjudicatory reason? Because I realize in some towns, like the town councils, like the traffic authority, or deals with certain fine hearings. So would that be something that might be, I'm hearing would be more palatable?
I can speak to like if narrowing it would be more palatable, like how it would be narrowed. I would have to give some more consideration to who it would apply. Again, we don't know. I don't know all the all the boards and commissions with the municipality. So it may be appropriate to some, but not to others. So we'd have to give some more thought to that.
Okay. I mean, I think that the enthusiasm of the legislation is to say, listen, we want to be as open, as transparent as possible and provide for as much public participation as possible, which I think is the spirit of why it's written the way it is. I certainly understand your concerns and the practical, concern, that you raised about the adjudicatory hearings and public entities that meet in that manner. So I would tend to agree with you in that regard. So hopefully, assuming this does move forward, we can start to more narrowly tailor it. As we like to say in the legislature, it's a work in progress, but I think it's a worthy one. So I'm hopeful it'll continue. Thank you for your testimony, and thank you, Madam Chair.
Thank you, Representative. Representative.
Thank you, Mr. Chair. Thank you for being here today. This proposed legislation does cast somewhat of a wide net. One of the solutions that I believe that our good ranking member had suggested is limiting it to legislative body. In some municipalities that might work, but if you have a town without a charter that's going by statute, the only legislative body that we have is the town meeting. So I think that just may narrow it a little bit too much. You had mentioned, and I agree with you on this, that certain meetings such as assessment appeals may not be appropriate for public comment. And I'm hoping that this bill may go further, get refined further and come to a vote in the committee. But in the meantime, could we possibly rely on some of your expertise in dealing with which ones you might think are appropriate? Or which ones might not be appropriate for public comment from a freedom of information standpoint? And I'm not asking you to do this today, asking if you could possibly work with the committee to be able to make this maximum transparency without jeopardizing some of the privacy issues.
We'd be happy to work with the committee.
Yeah, I'd appreciate that because I think there's this particular legislation is going to be important for transparency. And I know most of our municipalities do offer public comment most of the time. If sometimes at the beginning, sometimes at the end of the meeting, sometimes both. And it's a great example, but not every single one does. And this is what the legislation is intended to deal with. To have the public participate in meaningful meetings, boards of finance, town councils, in order to provide their input and make governing in a municipality a better thing. So again, I appreciate any assistance you can provide and appreciate your input today. Thank you. Thank you, Mr. Chair.
Thank you. Next, Ian Thomas, please.
Thank you, Mr. Chair. Yeah, so just real quick, I'm in support of the HB 5796. I'm a resident of Groton, and you know, to follow up on Representative Baumgartner's discussion points there, I can speak to a couple issues. First and foremost, I did submit written testimony, so I'm not going to reiterate that at great length here. So I'd encourage people to refer to that. But I'm in support of more public comment. I can understand the concerns about adjudicating hearings. Yeah, probably with some exemptions to be written into the law to allow for those to not have public comment. But in my experience in Groton here, they've over the past many years, there's been a steady restriction of availability to comment, especially at town council meetings and Board of Ed meetings, to about once a month. And what tends to occur, especially at town council meetings, is that any sort of issues, we end up with a bit of a lot of people. And in fact, so much that the town mayor made a comment in a recent article about 3-hour-long public comment sessions, which, you know, is kind of the nightmare scenario that a lot of people put out there. However, that I believe is more of a symptom and not a symptom of a problem. I believe more frequent comments and availability to comment would diminish any sort of one instance of marathon comments. Typically at those meetings where there's longer comments, there's some contentious issue or a couple contentious issues that the town council has been working on in the month prior to during committee of the whole meetings, or that are maybe coming up in the next coming month. So you end up with this huge list of people that want to speak to any number of issues, and they only have one opportunity a month. And typically we get 5 minutes. If there's a lot of people, then we get reduced to 3 minutes. So I think just for consistency and predictability, you know, there would be great benefit in having a law like this that would just kind of standardize that any sort of public meeting, legislative, otherwise. Again, I think the language could be constructed in a way that maybe just excludes the one particular or a couple particular instances where it would not be appropriate, and just, you know, err on the side of inclusion as opposed to exclusion. But I think it would help a lot, you know, as far as increasing the sense of public participation and civic engagement. Again, you know, it is the essence of local government for us to have, you know, access.
Please summarize.
Thank you. Yeah, it's unfortunate that we've had to come to this level for the state to get involved, but it is at this point necessary, I believe. So thank you.
Thank you very much for your testimony. Representative Baumgartner.
Yes, and want to thank Mr. Thomas for coming up to testify, and want to also thank you for your service to the representative town meeting. We are on the planning and zoning. I'm sorry, the planning, Freudian slip there. Planning and development committee. And obviously in Groton, we are a bit different than most other of our 168 municipalities in the state. We have a very unique form of government where the RTM functions as a body to counteract the work that the council does and serves as votes on our budget, and a deliberative body that does not exist in most of our communities. So I want to thank you for that as well. And just about the underlying bill, can you speak to any amendments or items that could improve the bill as you see it written?
Yes, thank you. Yeah, in particular, I had concern that the phrase on the agenda, any item that's on the agenda, I think that language maybe should be looked at to allow for public to speak if this bill moves forward, to allow the public to speak to matters that may or may not be on the agenda, that may just be of concern to the municipality. Because there is a long history in this town in particular of public comments being the canary in the coal mine, so to speak, where some citizens will come out and speak to an issue that's not even on the radar of the town council or the RTM or the Planning and Zoning Commission or whatever agency it is that's in question. So I would be concerned about that. And also, in regards to the manner in which the agency members can respond to comments, as you discussed earlier, I think there should be some protections there, something established, clearing up the gray area, because again, down in Groton here, we've heard a lot from a lot of mayors and chairs saying that we risk violating FOI regulations if we respond to citizens' comments, even if it's just an acknowledgement of their concern and an initial reaction of oh well, we'll look to make this an agenda item in the future, or I'll start lobbying for that, something like that. Just and having been on both sides of the equation, I can definitely say that having been a citizen voicing those concerns, to have at least one or two from the agency members acknowledge our concerns would go a great way to ease the angst of whatever it is that brought us there to speak. Just some acknowledgement essentially would be good. And also one other item is the ability for the agency members to interact with each other during a regular agenda item discussion. We've seen our council be restricted in a number of ways as far as times and speaking times and the amount of times turns they can take in speaking on any issue, with no exemption, whether it's a budget concern or anything else that is going on that may require more vigorous discussion or deliberation.
Yes, as you've shared, there are time restrictions for counselors akin to what you would see in Congress, not this committee, and hopefully that remains to be the case. But nonetheless, just one follow-up question on the FOI commission testimony. They did provide testimony as you shared. Counselors at this time are restricted from providing responses to citizen petitions. And so can you speak to any specific language changes you may like to see to prevent that from happening in the future? As was mentioned earlier, the alleged violation, FOI violations, by speaking to issues of concern, even if the item is on the agenda for discussion. On the agenda. Thank you.
Yes, I believe there is a way to we look at the language. It's all about getting the wording right, but I believe there is a way to allow for the agency members to respond to the citizens and acknowledge their concerns without necessarily veering off into discussion with each other at that moment. There's a way to do it that could allow for that acknowledgement of receipt and maybe an initial reaction to the public comments, but then still respect the parliamentary procedure required to add any full discussion items to a later part of the agenda or to another meeting.
Thank you, Mr. Thomas, and no further questions, Madam Chair. Thank you.
Thank you so much. Seeing no further questions, thank you for your testimony today.
Thank you.
Up next, number 21, Mike Glidden. And on deck, Betsy Gara.
Good evening, good afternoon, I'm sorry. Mike Glidden, I'm the president of the Connecticut Association of Zoning Enforcement Officials. We're here on 3 bills. The first one's House Bill 5796. We have some concerns about this as it impacts regulatory agencies. I brought up an example of if you have an application that goes to a public hearing, and if you have, it already has a opportunity for the public to comment. Once that application's public hearing is closed, having an ability to have the public a second chance, a second bite of the apple could just create confusion, and at the same time could create a legal conflict where what exactly is part of the legal record for that application. So because of that, I know you've talked about changes, maybe excluding some of the regulatory agencies would be an appropriate change to this. Next is we're here on Senate Bill 918, and I'm just going to really quick summary on this one is it's a great bill. It really, what it does, it's going to streamline the land use process without ignoring statutory requirements. So no longer, as you heard earlier, applicants are going to spend additional attorneys, engineering costs going through the land use process with multiple coastal site plans. Instead, it would be the last stop on your regulatory journey is where the coastal site plan will be reviewed. The last is Senate Bill 915. From a concept standpoint, we support this change to 8-6. However, we have some areas that I think deserved a second look. One was in line 49 and 50 and 63 and 64, the term character of the neighborhood is being used. That was removed from the zoning enabling statutes, the Public Act 2129. And if this were to remain, that conflict should be addressed, and that those areas where character of the neighborhood should be removed. It's a real discretionary term. The other is on line 77 and 78. Now, when someone goes to an area variance, they're saying that you want to look at consistency for the plan of conservation development. From a use standpoint, that may be appropriate, but from a setback or you want to build your house, you want to build your addition taller, or you want to reduce some other sort of performance standard. The POCD does not get down to that level of detail, and therefore it's not an appropriate standard to be invoking that advisory document in that day-to-day administrative decision when it comes to a area variance. I think that, we've said in our testimony, that 915 really, it provides a uniform approach throughout the state when it comes to variances. Variances right now, it is such a strict area that our ZBAs, our ZBAs deal with, and this would just make it a level playing field throughout the state. And I thank you for your time.
Thank you very much for your testimony. I would say thank you for pointing out the characters section specifically, as we have heard it a little bit, but not a lot. And sometimes we overlook things. So that was really helpful. And otherwise, seeing no questions at this time, thanks so much and have a wonderful afternoon.
Thank you. You too.
Next up, we have Betsy Gara, and on deck is Frank De Felice.
My name is Betsy Gara. I'm the Executive Director of the Connecticut Council of Small Towns, and I'm pleased to be here today. We've submitted testimony on several bills. I just want to touch on a couple. COST does have significant concerns with House Bill 5796, an act requiring public comment at certain public agency meetings. As drafted, this bill applies very broadly to public meetings where a public comment period may not either be appropriate, warranted, or even practical. And I know we've heard some discussion about that already. Certainly, there are municipal boards and commissions that are dealing with adjudicated cases. They may also involve special meetings, executive sessions, There are some local boards and commissions that had site visits to walk properties and determine certain issues with respect to those properties. All of those types of meetings, it would be impractical to have a public comment period at those types of meetings. I'm also concerned that, is particularly in listening to the discussion, that this bill opens the door for legislation to determine not only that there be a comment period, but the length of the comment period, that they can comment on items that are not on the agenda, that they may have to engage with have the opportunity to engage with the committee members regarding issues that may not be on the agenda. Clearly, it is well settled that municipal boards and commissions and other public agency meetings have the right to determine how to set the meeting in order to provide it or to serve the legitimate interest of holding a meeting in an efficient and orderly manner to ensure that they get their work done. So again, we're supportive of efforts to ensure that the public agencies operate in an open and transparent manner, but we are concerned about this particular bill as drafted. In addition, I know I did read the comments of some that have suggested that the bill be limited to municipal boards and commissions. And I think that that would be very unfair. I think if you're going to determine that a public comment period needs to be mandated, it should be applicable to all public agency meetings and not just limited to municipal boards and commissions. Thank you.
Thank you very much for your testimony. Representative Baumgartner.
Yes, thank you so much for coming out to testify. This year I have the privilege of representing a small town, the southeastern corner of our state, Stonington, and also with a very unique form of government, fire districts, subdivisions as well. And so Dave did an article about this and actually looked at many of the municipalities that do allow for public comment or receiving of public input. And it was very clear that many of our small towns, and in many cases actually invite our citizens into the deliberative process. And actually citizens are able to weigh in during meetings and not be held afoul of, of breaking any statute or, Robert's rules, et cetera. And I think in many ways you can have an organic discussion about issues in real time as opposed to when, an issue is expected to be voted on. So can you speak to ensuring that, or speak to the existing system that allows for that organic discussion and deliberation in those meetings?
Well, I think you're absolutely right that the vast majority of municipal officials want to engage the public, want to get input from the public relative to various matters that are considered by the local government. I know that the Advisory Commission on Intergovernmental Relations, for example, has published a best practices for holding municipal meetings, which we've provided to our members, that outlines some of the parameters that towns should consider in terms of holding those meetings in an open, transparent manner. So we are certainly open to those discussions. Again, I am a bit concerned that this legislation opens the door for some comprehensive, specific requirements that may not be productive overall. And so we'd have to be careful about that. But we would certainly be willing to discuss this.
Thank you so much.
Thank you very much. Representative Zawistowski.
Thank you, Madam Chair. Good to see you here today, and thank you for your leadership of small towns. Small towns in our state really need to have a strong voice, and you've done a great job over the years. On this bill, this is indeed a work in progress, and you've had some good suggestions. I believe that I don't think there's any intent here to be able to micromanage how towns would manage public comment. I don't think, the number of hours or anything else. As a matter of fact, I think it specifically mentions that this can be set by the municipalities. But you also mentioned as a question for you, opening it up to other public agencies. What do you have in mind as far as other public agencies go?
I was just suggesting, because it is currently drafted, the bill applies to all public agencies, including state agencies. And my point is that I think it would be unfair to create one requirement under presumably this was fall under the Freedom of Information Act to hold public comment period at municipal boards and commissions and not at other state agency meetings, whether it be the Department of Energy, Environmental Protection, Public Health, et cetera. So I
Okay,
think you need to be consistent with respect to the Freedom of Information Commission, which requires notice and an opportunity to attend and so forth, that should be fairly applicable to both state and municipal agencies.
Okay, and thank you for that. As this is something that we're still working on. I think any input that you might have would be very welcome, and appreciate your time here today. Thank you. And thank you, Madam Chair.
All right, thank you. And I know you're very, very good, Representative Zavistowski, about reaching out and working with us on these issues. So I appreciate that.
Thank you very much. Seeing no other questions at this time, thank you for your testimony. Up next, we have Frank DeFelice and Randy Collins on deck. And I apologize, Frank, if I got your name wrong.
Close enough. Thank you very much. Honorable members of the Planning and Development Committee. My name is Frank DeFelice, and I currently serve as the chair of the Regional Planning Commission for the Lower Connecticut River Valley Council of Governments, which represents 17 of Connecticut's municipalities. I'm also the chair of the Planning and Zoning Commission in Durham, Connecticut. And I'm testifying today in opposition to Senate Bill 915, an act concerning the granting of variances by Zoning Board of Appeals. A couple of points I'll make. Let me start with the first one. Zoning regulations are uniform for a very good reason, and that is equity. Zoning regulations are applied uniformly for a good reason, and that's to create an equitable playing field for all. This bill strips away the uniform treatment of all applicants and residents by individualizing approvals, and in doing so, strips away equity. As the decision of a zoning board of appeal only applies to a specific applicant and their individual land parcels, there can be no uniformity. And this is unfair to the residents of the community. Second point, this bill contains no objective standard for the approval or denial of a variance. The bill contains no approval, no objective standards, and in fact, ZBA members only have to weigh certain factors to render a finding that will benefit the applicant and would, in a way that would exceed any adverse effect to the health, safety, or welfare of the neighborhood of the community. But the ambiguity of the standard makes it virtually impossible for either an applicant or a member of the community to successfully challenge an approval or, equally important, a denial by ZBA in a court of law. And that's unfair to both the applicant and the community. The next point I'll make is that this bill establishes two avenues for securing the same permit. The language of the bill would expand the purview of ZBA to the granting of special exceptions, or sometimes people call it special permit. This would result in two independent agencies, zoning and ZBA, being able to approve or deny a special exception or special permit for the same or similar land use issues, resulting in a conflict and potentially expensive legal quandary for the municipalities. You think about it, to my knowledge, there's no two state agencies and no two agencies within a single municipality even that have ever issued the same permit, license, or registration for good reason. So this is really two agencies that can do the same thing. Either one can grant the approval. It kind of goes against what we've seen historically with any departments or any agencies. Final point is that allowing ZBA to approve use variance is a significant and permanent concern. Zoning boards of appeals are currently empowered to vary dimensional requirements when it's necessary. However, this bill would expand their purview to approve use variances.
You summarize.
For uses that are currently prohibited or not otherwise allowed. In similar fashion, these use variances run with the land forever, and the concern with approving them is that they can redefine an entire neighborhood or an entire section of town, since the language in the bill contains no limit on the types or sizes of uses that can be applied for. I thank you for your time, and I'll be happy to answer any questions.
Thank you very much for your testimony. Seeing no questions at this time, have a wonderful afternoon.
Thank you very much.
Up next, we have Randy Collins, followed by John Guskowski.
Good afternoon. And nice to see everybody here in person. My name is Randy Collins. I'm an advocacy manager with the Connecticut Conference of Municipalities. CCM submitted testimony on numerous bills today, actually submitted by Donna Hamzy-Carocha. But I'm trying to fill in for her. I will do my best. Just quickly wanted to touch on a few quick issues. The first one I wanted to talk about was House Bill 6559, an act concerning zoning regulations for community residents. We have concerns with the deletions of lines 25 through 40 in section 1B, which takes away a resident's right. It's a process by which if a resident believes that one of these community homes is operating out of compliance, could be for number of occupancy or the stated purpose or the mission of them, that they can go to the town, and if the town agrees, that they can go to the state agency that oversees that residence regarding compliance. I don't know why we would take that right away from a resident to say they're non-compliant with how they should be operating. As I said, it could be occupancy, it could be any number of reasons, it could be safety, safety related. So if we see those, we should be able to have a process by which we report them up. The other next two bills I wanted to quickly comment on, 6557, 6558. Both of these, one would increase the amount of the tax exemption for tangible property, would raise that threshold. It's going to cost towns money, and without even providing any semblance of savings, the assessor's still going to have to go in and do that same amount of work. We're just going to be able to collect less money on the backside. The other one at 6558, property tax abatement for certain home buyers. Again, this is an unfunded mandate and it further erodes the property tax system. I think a lot of the discussions that we have revolve around the idea of the property tax is regressive, and it's not it's an impediment to home ownership. It's an impediment to our economic growth, and that we need at some point to really wrap our hands around it and look for, comprehensive property tax reform that will provide benefit rather than nibbling around the edges and providing limited relief for selected parties. I like to echo the comments that Betsy Guerra from COS had made on the public agency comment period. And I will kind of leave there and ask if there's any questions.
Thank you very much. Seeing no questions at this time, thanks for being here. John Guzkowski, please.
Thank you, Representative Carlos DeGraw, Senator Rahman, and the members of the committee. My name is John Guzkowski. I'm a professional planner and certified zoning enforcement officer, and I represent the Connecticut chapter of the American Planning Association. I am the Government Relations Committee co-chair. CCAPA represents more than 300 land use planners, attorneys, landscape architects, and allied professions. And we, along with the Connecticut Bar and Casio, both of whom you heard from this afternoon, we are the experts and the administrators of day-to-day land use decision-making at the local level in Connecticut. We have submitted testimony on two bills supporting both Senate Bill 918 concerning coastal review and Senate Bill 915 concerning ZBAs and the granting of variances. Briefly, for Senate Bill 918, we echo comments previously from today, noting that requiring development applications to have to go through the coastal plan review multiple times at the local land use level is unnecessarily costly and redundant. It should only have to be reviewed once, and that should be, as Mike Glidden from Casio recently stated, it should be at the last step so that all interim site changes as it goes through the rest of the land use process are completed and locked in, so this can just be reviewed once. For Senate Bill 915 concerning ZBAs and variances, we echo the comments and testimony submitted by both the Connecticut Bar and Casio. While none of our individual organizations are totally unanimous about it, all three organizations strongly recognize that our current system of granting variances is fundamentally flawed and needs to be addressed. Some Superior Court estimates have indicated that roughly 9 of 10 area variances currently granted or recently granted in Connecticut are granted illegally by ZBAs. And this is not to say that these granted variances are bad. And in many cases, they are the just and equitable and fair decisions regarding land use development for the ZBAs to make. But it's just that the current statutory standard of hardship is unnecessarily rigid and far too high for virtually any ZBA application to meet. What this bill does would not make it easier to get a variance in practice, Indeed, the problem is that the most appropriate and just variances are in fact granted, but they're granted illegally. This bill would just add some structured decision-making to the process for area variances. And it would ensure that the method and methodology that every ZBA in the state would be following the same procedure in the same structured and legally defensible way. It would not change the process for the process or standards for use variances, which should be exceptionally rare. It just brings, again, a structure and rigidity to a process that is being daily defined
Your 3 minutes
illegally
are up. Please summarize.
59 different ways across the state. So we would urge the passage of that, and I'm happy to answer any questions. Thank you for your time.
Thank you so much. Representative Chafee.
Thank you, Madam Chair. Thank you for testifying today, John. I was just curious, can you give some scenarios where someone would need to submit multiple coastal review plans?
Sure, that happens in most cases. If you are, let's say, you are getting, you have a property on the shore, a beach house or something like that, you're getting a variance to add a deck. The coastal site plan review would have to be done at the ZBA level. Once the variance was granted, if it was granted, then you would have to get maybe a zoning permit or a special permit from the zoning planning and zoning commission. They would have to go back to the coastal review period. You'd have to resubmit that. If there was, for instance, a wetlands consideration, it would have to get submitted in association with the wetlands permit also. So it's actually, it's more rare that there wouldn't be multiple reviews than there would be, a circumstance where it would be reviewed only once.
So is it the same report is being resubmitted each time, or does the applicant need to amend the report depending on what they're doing?
It depends. I think if the application does not change through some of these processes, then it would be the exact same site plan and proposed activity in multiple applications. Sometimes if you have, like, say you go to wetlands first, and wetlands, encourages you to maybe reduce the side impact or use some sort of different erosion and sedimentation technique. It's technically the application of the site plan changes. So there would be a slightly modified version that would go to coastal review. But for the most part, the project is the project.
Okay. I know someone who testified earlier. I don't remember the exact scenario, but it was in regards to installing a parking lot, and then they were going to do some other work. Obviously, when you install the parking lot, it's going to impact the runoff and storm drainage and things like that. So in that case, would it make sense to go through multiple reviews?
Well, if the actual project is phased and, someone's applying basically just to pave a parking lot, and then they go through that process, and then maybe a couple months later, they look to add lighting or add a building or an accessory structure, that would be treated as two separate projects entirely. But if you're, showing the entire project, that includes redeveloping the property, that includes the parking, the drainage, regrading, everything at once, it doesn't make sense to have to go through multiple iterations of a coastal review.
Yeah, I agree with that. Is there a fee associated each time they have to resubmit, depending on?
I don't believe, I could be wrong. I don't believe there is a fee for the state. I think it's basically a referral from the municipality to the state.
Okay, thank you for the information. Thank you, Madam Chair.
Thank you very much. Thank you for your testimony. I see no other questions at this time. Up next, number 26, Portia Bordelon.
Hello, thank you, and I apologize for my decor, or I shouldn't apologize. I'm headed off to a Black History Month celebration for 3 o'clock, so I apologize. I must be quick and brief. I did submit my remarks to you guys in writing. My name is Portia Bordelon. Thank you, Madam Chair, for your work on this in running this meeting. My name is Portia Bordelon. I'm a Groton Town Councilor down here in Groton, Connecticut. I'm in support of the Bill 5796. One of the reasons I am in support of this, I'm a firm believer in transparency, accountability, and accessibility. As of right now, as I'm trying to race off and the date, for this public hearing, as we are so lucky to have the opportunity to have our voices heard. In a town municipal in the town of Groton, they only offer one public comment a month. Same for Board of Ed. Board of Ed is, don't quote me on the numbers, 70-something% of the total town budget. I do think that this causes a backlog when people show up because they feel the urgency, the frequency, the irritability to feel like they need to speak and they want to be heard on these matters. Opening this up where there's the ability to speak at every month, the issues would be key and pertinent to the matters at hand. Currently in the town of Groton, we will have a meeting, and the last meeting of the month, I have no control as a council with the agenda. It's the mayor and the town manager. We do not have a strong mayorship. We have a town manager that's appointed. They may put things on the agenda that nobody knows. It comes out on Thursday night, and they can't speak until the first Tuesday of the month. That's not transparency or accountability. As an elected official, I'm no good without my constituents who vote me into office. Their voice should be our priority. As a person who's campaigned, I've always stated, I have no agenda. My agenda is the people. And that agenda kind of waxes and wanes depending on what's going on. And to have that flexibility and that opportunity and that voice, once a month on a Tuesday at 6:30, you're allowed to speak down here. What if you work second shift? You can never come. Oh, but maybe if it was offered several nights a month, you could kind of alter. Does not work towards the single mom or the other varying populations in our community that are vital. I feel that minorities are underrepresented in this section, as well as people with disabilities, as well as single mothers. A big issue in Groton here has been mold. Women in low-income housing have been coming out more than ever lately, and they have to hold for once a month. I just think that this is a great opportunity. I think there does need to be some tweaking to this bill, but I think this affords us a chance to say, we are elected at large by our constituents and their voice matters. When we take that away, what are we all here for? So that's where I stand on this. And I apologize. I had something typed up and I was going to speak, but I have to be at my ceremony for 3 o'clock, but I do appreciate all the work on this. I would like to see some things altered in the bill. I encourage, to reach out to municipalities. But I do think there is a strong argument to make sure if you're going to raise a topic, you're allowing
Summarize.
Thank you. If you're going to raise a topic, you're allowing the ability of the people that it's going to directly affect the opportunity to be able to come around the table and speak to the issue. When we block the voice of our community, we are doing our community no justice. So again, thank you. And I want to thank, Representative Connolly and Baumgartner, who's, represent this district directly, and their good work and always willing to listen to us any chance they can get. Thank you and have a wonderful day.
Thank you so much. Just hold on one second. We have a couple questions for you, I think.
Sure.
I also want to just point out that it's very helpful in how you elucidated that, because for a lot of us, this is already happening in our communities, but it's very clear from what you said, what the struggle is in Groton. And I think you're well represented there. Representative Conley.
Thank you. And Ms. Borland, if you do have to leave, just let me know. I know you do have that event.
Yeah.
But I wanted to touch base on a couple of things that I've seen and heard, and I know you've seen and heard as well. When you've been serving as a counselor, I know that items change from a committee meeting, like similar to how we work a committee meeting today, to when you have things on the floor. And at this time, how the current system is, I want you to maybe let our members know very briefly, how with the current public comment not being at each meetings, how if a proposal changes, the residents may not have the ability to speak on that.
Yes, thank you, Representative Connolly. It's tough. I mean, when you're not able to respond to citizens in real time either, and just kind of thank them. If a mother comes out, she has her kid on her hip and she's complaining about mold in her low-income housing unit, and we're told here in Groton that we cannot respond because it's not on the agenda. I can't even thank them. Currently, under the way that it's set up for me right now, I can't even say thank you, John Doe or Susie Smith, for taking the time to come out. I hear you. I'm gonna, make sure I write this down, and please contact me. If it's on the agenda, I don't understand why I couldn't ask pertinent questions or direct comments that would be appropriate. Currently in our municipal government as well, I'm voting on millions of dollars. I'm elected to vote on millions of dollars. And they've changed the rules to allow us to only have 2 turns per topic. 2 turns, 2 to 3 minute turns per topic, millions of dollars. So how is that democracy? How am I elected at large to do the work of the people when they're changing rules on the government to limit the people who are elected by the people to be their voice, and then cutting the public comment down? So I'm the one that's supposed to be able to speak. There's times I go to meetings, if it's a personality conflict, because I know I'm speaking for a certain side of town, they won't even acknowledge me as an elected official if they don't choose to. I serve on a group called the Property Reuse Committee. And I said one of the contingencies of being a part of that is public comment should be on every meeting. It's never been abused. We've been going at it probably 8 weeks. We've had 3 to 4 people speak. We can recognize them from the floor if we want, if we have a question about what they stated. It's wonderful. Other small committees that I've gone to, they won't let you speak. They won't let you speak on it until it comes to be presented to vote on. That's too late. Now you have the army out the door that's upset. I think we can do better. We should do better. Transparency, accountability, and accessibility for everyone is so vital in every community and every town.
And with some of these problems that have come maybe on certain ideas or come through the press that you've been aware of, if you had been able to have more public comment earlier in the stages of the issue, wouldn't have been better for the project and maybe stopped, or the project could have been amended in a way that the public supported if the public had an opportunity to weigh in earlier?
Absolutely. I totally agree with you, Representative Connolly. For example, there's a property that's in town that they're going to repurpose that's currently a school. And I stated at several meetings, they already went to a drawing and a recommendation. And I said, this is where we bring the public in. And I was outvoted. But absolutely, if you bring people around the table, my mother used to say, if you bring the people that it's going to affect around the table early, then you're decreasing the ability for the pushback and the concerns that people have that come across as more direct and hostile at times. Hostility and people feeling like their voices aren't being heard then creates this anxiety and that control, that one night a week where, as it was stated by other people that spoke, one night we had 3 hours before we got to town business of comments, which is wonderful. But if we had it multiple times a month, we would be able to address it. And again, I'm here to do the work of the people, and the people should be at the forefront of any meeting within limitations for FOI requirements. It should not be stifled. One of the things I heard is people have concerns with government. They don't trust us. Minority community overwhelmingly. People have come up to me and say, I don't trust you. I don't trust what's going on. Elected officials are out. They have their own agendas. That's the reason I got involved, was to change that. How we change that is allowing people to speak. When you open that door, you say there's nothing here that you don't want people to know about. So that's what I'm all about. And I just think that you're on the right track. I think the wording, could be added. I'd love to be a part. I think this is a great option, because even though some municipalities do it, not all are. And in our town, as it was stated, we don't have a strong mayor. We have an appointed mayor at large. It's a 9-member council with no minority representation. What happens if it turns all one party or the other? Some would say that's a benefit depending on what side you're on. This is a bipartisan bill that's could have teeth in it that could help everybody. And my concern is down here in Groton, where we don't have minority representation, if something happens, they can just make rules to shut everything down. No one's voice is heard. You guys have the power to make change, and I support you all, and I thank you for the time.
Thank you. Thank you, Madam Chair.
Thank you. Representative Baumgartner.
Not sure I have a question, but just a comment. I want to give a shout out to my sister in service, Portia Bordelon. Have the privilege of serving with on the council, and so appreciate you willing to take the time to speak to us. I will be on the road shortly to join you for our 2nd annual Black History Month celebration, and just want to hat tip you for your continued efforts or helping organize it with our town. But just one question. It was brought up, about potential abuses by concerned citizens to abuse their public comment privileges in order to create maybe a drama or chaos around certain issues. And so can you just state to some of that potential criticism that may come from this legislation?
Listen, if a person wants to come out every meeting and speak to something that they're passionate about, what are we concerned? What drama should be created? You know, if it wasn't for the women of Branford Manor that have come out overwhelmingly and spoke about the mold concerns, some would call it drama. Some people roll their eyes when they show up. Some people say they don't want to hear from them, you know, by the mood in the room. I'm willing to sit there. If I'm truly elected to do the work, I will sit there as long as it takes to get the job done. I don't care how many times you come. If I have an agenda as a public citizen and I elected you at large, doesn't mean I'm going to vote for that, but you have every right under our democracy to show up. If you make the time every week to make sure you're there at 6:30, I commend you. I think that's appropriate. I think it's important, and I think it's their right to come. We did not get here as a minority community without people exercising that right over and over and voicing their concerns overwhelmingly, that they were concerned about certain things to make sure that we have gotten as far as we have. So if we had given up on that, where would we be? And that's all I'm going to say. It's not exercising their right to make changes. It's their right. I don't care how many times they come. It's their right to do that under our governing documents, you know, that we have before us. Thank you.
Thank you for testifying in support of this bill. We'll see you soon.
Thank you very much. Travel safely to your event.
Thank you.
Up next, number 27, Everett Weaver.
Yes, good afternoon, Madam Chair. Members of the Planning and Development Committee. My name is Everett Weaver. A little perspective on what I'm going to be talking about is Raise Bill number 6916. I'm a 34 plus year member or operator of treatment facilities, a 20 plus year member of my local WPCA, and a member of the Connecticut Water Environment Association Legislative Committee. Passage of this bill, for lack of a better term, would be an egregious fiscal irresponsibility to WPCAs. The liens and foreclosure are our only means of enforcing collection. We cannot shut off utilities such as other utilities can. No WPCA wants to foreclose on a property. We want to work with those people in order to be able to set up a financial plan so that they can pay. Some personal perspective. So my sewer bill, if to reach $4,000, would take me 21 years to reach. Applying that ratio to some of my other bills, I would owe over $128,000 in taxes, over $40,000 in electricity bills, over $28,000 in oil, over $12,000 in water, and cable and internet would be $55,000. Now, as Mr. Kaluski mentioned earlier, it's a 15-year limit on the being able to collect on your fees. I would never reach any of those respective limits if they were applied to all those other bills. After 15 years, your first bill is eliminated. And also, it was mentioned earlier that there were only 2 entities that were problematic. And it's not in none of the other WPCAs. As I say, most WPCAs want to work with their with their ratepayers in order to be able to collect those fees. I'd be happy to answer any questions that you have. Hopefully, and I kind of hope that you save the best for last, but hopefully this will all end shortly for you. Thank you very much.
It goes as long as we need it to go. So thank you very much for your testimony today. Seeing no questions at this time, thank you. Have a wonderful afternoon. And that does conclude our public hearing. We have our next committee meeting this Friday. Thanks so much.
Thank you very much.